Please have a hearing on IA tomorrow. Search.
Tomorrow.
Serial number 16.
Adjournments,
Yes,
list one, page number 1 to 6, page number 2, serial number 7 to 15, page number 3, 16 to 26.
Serial number 16, my lord. I am for the respondent.
And for the petitioner, my lord.
Next week.
Date may be fixed, my lord.
Release the matter on
27th.
Yes.
17.
17.
Kindly call this matter along with CP 351/23. That's CP filed by me.
27.
CP 351/23 filed by the respondent.
List,
Connect
list along with CP number
351/23. 351.
on short date
20th.
20th.
Serial number 21, my lord.
Yes,
This week time may be granted, my lord. I am for the petitioner. I inform the others.
you have informed.
Inform.
At request, list the matter next week.
Interim order.
Interim order earlier granted is extended till the next date. Date code.
My lord, serial number 24, my lords, 24.
Very for the respondent. We have submission in this case.
Grace time for
We have submission.
collate the documents, my lords. Serial number,
We have submission, kindly follow it regular. We have submission in this.
grace time in this case, my lords. We need some time to
Let us see,
collate.
when it reaches, I'll accommodate.
Obligation.
Page number 4, 27 to 38.
Serial number 30, my lord.
30?
30, my lord, 30.
Yes.
My lord, 18 के one date ಕೊಡಿ. 18 के one date ಕೊಡಿ, my lord.
Have you informed the other side?
ಹ್ಮ್.
Then you wait. If you find the other side, intimate the court of.
My lord, senior ಗೆ ಹುಷಾರಿಲ್ಲ.
Correct.
Health ups.
When it reaches, I'll accommodate. I'll make a note and when it reaches, I'll accommodate unless you can intimate the others. Yes.
Page number 5, 39 to 42. Page number 6, 43 to 48.
45. That will not have a statement of objection for the respondent. Raise 1 week time.
Have you informed the
Yeah,
others?
appear for petitioner in this case.
It's a matter on date coding.
20th.
20th.
Please, ma'am.
Page number 7, 49 to 52. Page number 8, 53 to 57. Page number 9, 58 to 64.
My lordship, serial number 45, interim order. 45.
Yes.
Page number.
Oblige.
Page number 9, 58 to 64.
My lord, serial number 59, 60 and 61, I'm filing a memo for the withdrawal.
That counsel for the petitioner.
But these are voting right matter.
It's sought for voting rights.
Yes, same order. 61.
59, 60 and 60.
Page number 10, page number 10, 65. Page number 12, 66 to 70.
Have you informed the other side? Will inform. At request, list the matter next week.
26.
Interim order.
Interim order earlier granted is extended till the next date.
Page number 13, 71 to 75. Page number 14, 76 to 76 and 77. 15, page number 15, 78.
Remember what is the minister returns to announce the result without counting votes. Remember. Which is that, Siddharth, which is that order we passed in to not to count the petitioner's vote and declare the result?
Yes, my lord. I will give that.
Okay.
Next one, fresh matter, serial number 1, revision करके.
Petitioner is the borrower, my lord. Entire amount has been repaid in their.
You take out notice.
Please, title deed,
AG,
annexure B,
take out notice.
please.
Lord, in this matter,
AG accepts notice for respondent 2.
2, my lord.
What about 1?
Oh, yeah.
Emergent notice to the first Why do you want all those people? Who has to release is only three, isn't it?
Three.
Three has to release.
Please, not married.
Then we'll
The
dispense
formal
notice
party
for the
because-
first step.
The respondent number one is the formal party because
No,
of his
we-
authorities, my lord.
He's the,
Authority, central register of
we
cooperative.
dispense for the present, let us see.
Please,
Notice is dispensed with for the present as regards R1. Emergent notice to the third respondent. Petitioners permitted to take out notice by way of hand summons as well.
Please.
List the matter in the orders list week after next date code.
27.
oblige.
You complete service, we'll see what.
Please, please.
Page number 2, Harsha D, Sandeep.
This matter, I put for the petitioner, my lords. My lords, yesterday my lords indicated to prepare a table, my lords. They have prepared the table and served on me. They've given the list of voters who have not attended the meeting and the other table which reflects who have not availed the minimum services, my lords. So far as the ineligible voters who have not attended the meeting, I submit there is COVID relaxation in this regard, my lords. I may be permitted to avail.
That along with the petition only you must state, isn't it? Simply if you file petition with 300, 400 people with saying that interim order will be granted, they're asking how we
My
can
lords,
give.
apart from my lords, if I may
How is it covered?
please, my lords, if I may submit my
You have to demonstrate. Now, okay, insofar as COVID relaxation will consider.
please, my lords.
May- Non-utilization of.
I'll address my arguments in this regard. My lords, like I said, there is two bifurcations, my lords. So far as members who have attended, who have not attended 3 out of 5 general body meetings, there's COVID relaxation. So far as ineligible voters who have not availed the minimum services, my lords, the procedure adopted by the respondent number 6 society is in contravention to Rule 13D 2A, my lords. My lords, there's a clear departure from the statute which is prescribed, my lords. If I may read.
Correct, but now you must on merits. That is procedural violation is yes.
Yes, my
There
lords.
may be a violation of Rule 13D, but must you not demonstrate that you have availed the service?
My lords, kindly see, my lords, Rule 13D 2A states 15 days prior notice shall be given before 6 months 6 months election date is declared, my lords. Now what happens is in this 15 days I would have complied or availed minimum services, my lords. In the instant case, I'm supposed to supply 100 liters of milk, my lords. I would have done that, my lords, in that 15 days. If had I been given 15 days time. Code in itself, therefore there should be no deviation or digression from this, my lords. I will produce those 2 judgments before my lords, my lords. One is Mysore Chamarajendra District Cooperative Bank versus State, my lords. This is passed by the division bench of this honorable court, my lords. My lords, one other striking point here, my lords. My lords, the society has 427 members. If you see my, if my lord sees my annexure B, eligible voters list, my lords, it is 130, my lords. My ineligible voters list is 297, my lords. Kindly see, my lords, the ratio here is more than 70%, my lords. This will not only frustrate the election process, it will take away the principles of cooperative society, my lords. It will defeat. My lords, kindly see the principles or the amendment which was brought in Article 19(1)(c), my lords. The principle mainly laid down as democratic setup, my lords. That itself will be taken away. That will be defeated, my lords.
Now, what is the requirement availing of services within
15 days ಒಳಗಡೆ they have to
Year. in a year? Is
in
it?
a year.
Rule 13?
D2A.
195 days prior to date of elections, that notice has to be given.
13D,
2A, my lords.
2A, Roman 2.
If I may read, my lords. The chief executive, my lords, 2A, 2, my lords, Roman 2. The chief executive of every cooperative society shall send above prepared notice to all ineligible members 15 days prior to 6 months to the date of election of the board by registered post, and an opportunity shall be given to such members to file their objections, if any, within 15 days from the date of notice. My lords, kindly see here, my lords, my notice was issued in the 3rd month, that is in the November of 2023, my lords. This defeats the provision, this defeats the purpose of this provision, my lords. Had they given me 15 days time before the issuance of this calendar of events, I would have complied, my lords. That is my case, my lords. My entire case revolves
that
around.
all judgment you're relying on.
Please, my lords.
Which paragraph?
Please, my lords. My lords, in H.S. Raju versus State of Karnataka, my lords, if I may read para 10, my lords.
Para?
10, my lords. Internal page 71, my lords, 70 and 71.
Yes.
These provisions do not leave any room for the doubt that an excluded manner with the publication of draft eligible list must have an opportunity by way of an individual notice to the to file objections on exclusion from electoral list. It must be shown that the concerned chief executive has prepared and sent notice to the affected members. The public notice dated so and so does not meet the requirements. In fact, it is admitted on behalf of the respondents that there are deficiency in preparation of final electoral lists after the publication of the draft eligible list, and the petitioners have not been issued the individual notices. My lords, on this line, the notices issued has been set aside, my lords. My lords, my case here is, it is an admitted fact by the respondent number 6 society. They tell the notices issued in the month of November 2020. October.
Yes.
My lords, in the second judgment, my lords, the division bench of this honorable court has held that there should be no departure from the statute or deviation from the statute when it comes to election law, my lords. My lords, if I may read the writ appeal judgment, my lords, writ appeal 1333 of 2023, my lords, internal page 48. We noticed that Rule 13C2 of 1960 rules mandates the chief executive of the society to prepare electoral rolls, of course, which go for the approval of jurisdictional election officer. Rule 13D2 authorizes the CEA to publish calendar of events for preparation of electoral rolls and conduct of elections of the board of cooperative society. Rule 13D2A directs EO to take steps for publication of ineligible voter lists. Rule 13D4 casts a facilitative duty on the cooperative society in this regard. A similar duty also rests on the shoulder of so-and-so, so-and-so. My lords, here, my lords, if we draw cue from this judgment, my lords, it clearly tells the duties casted upon the society and the chief executive officer, my lords. Here, both of them have lapsed, my lords.
You also have lapsed.
Subsequently,
Hmm.
all
Now,
considering both the judgment, my lords, one last submission.
submission that is being made by
I
them
will give my lords.
is that let them be given an opportunity.
My lords, yes, my lords. Kindly see this judgment, my lords. Considering those two judgments. Para 5, my lords, page 10, 16. Respondent number 6 society has not complied with the requirement of Rule 13D2A of the Karnataka Societies Act 96, which are held to be mandatory in terms of law laid down by the division bench in Mysore and Chamarajanagar district, so and so. The non-compliance of mandatory rules will enable the petitioner to cast vote in election as the process holding the petitioners ineligible. Voters itself is contrary to the mandatory provisions of Rule 13D2A. He would also submit that in Mohammed Berry's case, this court has not allowed the petitioner to vote in the election and petition dismissed at the threshold. And H.S. Raju's case, this court had permitted the petitioner to vote in the election and noticing that there is no compliance on the part of the respondent number 6 society, while finalizing the voter list has permitted the voters to be counted. Thus, he is to contend that as the mandatory requirement is not followed, the petitioner shall be permitted to vote on the election. The Learning Council for the Respondent 6 would contended that the issue involved in this case is covered in terms of so-and-so, big Gangana versus so-and-so. He would also pointed out that H.S. Raju's case, Supra, the court permitted the voters to counted in the view of the concession made by the bank, which made a statement that Rule 13D2A is not complied. It is also contended that the Learning Council Respondent number 6 that the society has issued notice to all the petitioners and notices have been served. And despite service of notice, the objection to the notices not filed as such, the petitioner cannot raise a contention that they are eligible to vote and contest in the election. This court has reconsidered the contentions raised at the bar and also perused the records. Admittedly, Mohammed Berry's case, Supra, this court has taken a view that once the calendar of events are published, the elections process cannot be stopped, and writ petition under Article 226 Constitution of India is not maintainable, where the challenge is laid to the correctness of the eligible and ineligible voters list. In H.S. Raju's case, Supra, the court was dealing in a slightly different context, where there was an expert interim order.
We can do one thing.
Admittedly, we should notice they have not filed any objections.
Now, what we can do is we'll extend them the same relief as in the interim order passed in other matters.
Yes, my lord.
Now, let them, in light of the material that you have placed,
Yes, my
let
lord.
them take their stand with respect to each of the petitioners.
Yes, my lord.
That is on merits.
Yes, my lord.
Now, the fact is there may be a violation in the rule. That's a different matter. But on merits regarding their entitlement, let them respond to the material that you have placed.
Yes.
By the next date.
My latest judgment, my lords, I have given in last paragraph, my lords. Direction number 2. However, the liberty is reserved to petitioner to raise a dispute under section 70 of the Cooperative Societies Act 1950. If such a dispute raised, notwithstanding the dismissal of the writ petition, the authority shall consider all contentions raised by the petitioner relating to the eligibility or ineligibility of the voters list, and thereafter pass appropriate laws in accordance with law. The votes cast by the petitioner shall be kept in a separate sealed ballot box. If same is summoned in any election dispute raised in connection with the election to the board of the society, the same shall be placed before the authority summoning the same. It is further made clear that the impact on the election results shall have to be considered if the petitioner is found to be eligible to vote in the election, and thereafter appropriate order have to be passed in accordance with law. They have to raise a dispute, my lordship.
Correct. Now, even otherwise, let us assume that out of the 140 petitioners.
Yes, my lordship.
Even one person is not entitled. Then what happens? The whole thing goes.
Yes, my lord.
That they are also aware.
Yes.
Let us see. Let them have the
I have given the
satisfaction.
chart also, my lordship.
Let them have the
Both the
satisfaction
writ petition.
of exercising their vote, and then let them reply to your stand.
In column number 1, my lord, they have not attended 2 meetings, sir.
The Council for Respondent number 6 Society has filed a memo enclosing details of the ineligibility of the petitioners with relevant details. Same is taken on record.
In both the writ petition, my lordship.
Such a memo is filed in both the writ petitions. Full stop. The petitioner to take a specific stand, taking note of the material placed before this court. Full stop. By the next date. It's made clear that the petitioner will not be granted any further time. Subject to the above, there would be an interim order on same lines.
interim order granted, my lords. They have to file affidavit, my lords. Admittedly, we issued notice. In the reputation they have taken, you are not received the notice.
On same lines. As in WP, as passed in WP 6538 of 2024. Last one, pardon. Then Bekila, 6 respondent to place before the court registers. Now, any of you have placed material supporting in your memo, isn't it?
Yes, my lords. But I issued the notice, my lords. Let them file affidavit, my lords.
Yes, same order. List the matter on
Next.
My lords,
the
20,
election,
tomorrow, my lords.
Tomorrow, my lords.
the Tuesday. Huh? On Wednesday, by Wednesday, you must take your stand.
Please, my lords.
Sir,
My lords, in the meantime, my lords, one request, my lords, let the learned counsel for respond number 6 society inform that I may be permitted to vote by virtue of this.
So we have passed an order,
Please, my
as
lords.
we have done in other matters. Now, the only thing is you will have to respond to their specific
Please,
suggestions.
my lords, I'll do this.
In a separate ballot box, my lords.
Yes, same. But next time when you are filing, you have to ask every time when you are collecting fee from each of the petitioners and filing wakalat, you must ask whether you have availed services. If so, you produce your bank passbook like that. Don't
In
file.
this, in this, both the petition, 65 petitioners, common in both the petitions. Not 1 or 2, my lords, 65 petitioners.
You have to apply your mind, madam. Yes.
Number 3,
Great.
Keshav Bhatia.
Lord, serial number 3, I will take notice for all the respondent, my lord, and the connected matter is already stayed, my lord.
3,
If it
4,
is 2, 6,
5,
6, my lord.
6.
3, 4, 5, and 6.
Yes, ma'am.
AGA accepts notice
For all the respondents.
for respondents, for the respondents. Then interim order.
In
Interim
connected
order,
matters,
no
there
need
is
to
a
grant
number-
in this, my lord, because the statute is stayed in one writ petition. It is always stayed for
So list along with
ಇಲ್ಲ
Writ petition
ಲಿಸ್ಟ್
26
ಆಗಿದೆ ಇವತ್ತು ಏನಾದ್ರು ರಿಸರ್ವ್ ಆಯ್ತು ಅಂದ್ರೆ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಲಿಸ್ಟೆಡ್ ಇಟ್ ವಿಲ್ ಬಿ
ಇಲ್ಲ ಅದು ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅದು
ನಾಳೆ
ನಾಳೆ ಫ್ರೈಡೆಗೆ ಬರ್ತಾ ಇದೆ. ಇಟ್ ಮೇ ಬಿ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಮೈ ಲಾರ್ಡ್.
list along with.
WP. Serial number 7, Mohammed Tahir, 7.
For the petitioners council,
Yes.
the petitioner is the delegate of the primary society, petitioner society. The number of directors, members of the board is 13, 12 elected, 1 representative of Finance Bank. Finance Bank has not sent any representative till now. Out of 12 elected directors, 2 have died. So effective number available is 10. A meeting is held, Chitraturga DCC Bank, that is respondent number 6. Elections are due. They have issued the notice to send the delegate. Accordingly, meeting was called and delegate was elected. With regard to meeting, my lord, your lordship may kindly see the Xerox copy of the original is at page 20. Page 20. Serial number 5 and serial number 11 are dead. Six are present. There is no dispute dispute about number being 6. Other 4 remained absent. Serial number 4 is the resolution. Present petitioner has been elected as delegate, with all the 6 voting in his favor. The DCC Bank, while sending the delegate form under Annexure C, page 18, second para may kindly be seen. ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲಾ ಸಹಕಾರ ಕೇಂದ್ರ ಬ್ಯಾಂಕ್ ಚಿತ್ರದುರ್ಗ ಇದರ ಬೈಲಾ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ವಿವಿಧ ವರ್ಗದ ಸದಸ್ಯ ಸಂಘಗಳಿಂದ 12 ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆ ನಡೆಯಲಿದ್ದು, ಈ ಚುನಾವಣೆಗೆ ಬ್ಯಾಂಕಿನ ಸದಸ್ಯ ಸಹಕಾರ ಸಂಘಗಳು ಅವರ ಸಂಘದ ಪರವಾಗಿ ಒಬ್ಬ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರನ್ನು ಚಿತ್ರದುರ್ಗ ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನ ಚುನಾವಣೆಯಲ್ಲಿ ಮತದಾನ ಮಾಡಲು ಅಗತ್ಯ ಕಂಡು ಬಂದಲ್ಲಿ ಸ್ಪರ್ಧಿಸಲು, ನಾಮಪತ್ರ ಸಲ್ಲಿಸಲು, ನಾಮಪತ್ರ ಹಿಂಪಡೆಯಲು ಸಂಘದಿಂದ ಅಧಿಕಾರ ನೀಡಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ಣಯದ ಪ್ರತಿಯನ್ನು ಫ್ರಮ್ ಹಿಯರ್ ಆನ್ವರ್ಡ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಪ್ರತಿಯನ್ನು ಸಹಕಾರ ಚುನಾವಣಾ ಆಯೋಗದಿಂದ ನಿಗದಿಪಡಿಸಿರುವ ನಮೂನೆಯಲ್ಲಿ ಪ್ರತಿನಿಧಿ ಡೆಲಿಗೇಟಿನ ವೈಯಕ್ತಿಕ ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಇತರೆ ವಿವರಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು ಚಿತ್ರದುರ್ಗ ಉಪವಿಭಾಗ ಚಿತ್ರದುರ್ಗ ಇವರಿಂದ ದೃಢೀಕರಿಸಿ 10/3/24 ಬ್ಯಾಂಕಿನ ಕೇಂದ್ರ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಬೇಕು. What they say is, my lord, after passing the resolution, along with the resolution, it should be filled up in a prescribed form or the form that they have sent, and it should be countersigned or dradhikarisi approved or confirmed by the ARCS Chitradurga. This is a requirement which your lordships will not find under the Act, rules or bylaw. Now the ARCS passes the order at Annexure E, page 38. Page 38. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪತ್ರದಲ್ಲಿ ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲಾ ಸಹಕಾರ ಕೇಂದ್ರ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಇದರ ಮುಂದಿನ 5 ವರ್ಷಗಳ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆಯು 11/5/24 ನಿಗದಿಪಡಿಸಿದ್ದು, ಸದರಿ ಬ್ಯಾಂಕಿನ ಸದಸ್ಯ ಸಂಘದ ಬುರುಜನರೊಪ್ಪ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಹಿರಿಯೂರು ತಾಲೂಕು ಈ ಸಂಘದ ಪ್ರತಿನಿಧಿಯಾಗಿ ಕಳಿಸಲು 5/3/24 ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆ ನಡೆಸಿದ್ದು, ಸದರಿ ಸಭೆಯಲ್ಲಿ 6 ಜನ ಮಾತ್ರ ನಿರ್ದೇಶಕರು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಆದರೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ನಿಯಮ 14(a)(4) ಪ್ರಕಾರ ಅಗತ್ಯ ಕೋರಂ ಇಲ್ಲದಿರುವುದನ್ನು ಗಮನಿಸಲಾಗಿರುವುದು. ಸದರಿ ಸಂಘದ ಬೈಲಾ 41 ಪ್ರಕಾರ ಆಡಳಿತ ಮಂಡಳಿಯ ಬಲ 13 ಜನ ನಿರ್ದೇಶಕರು ಇರುತ್ತಾರೆ. ಕೋರಮ್ಮಿಗೆ 7 ನಿರ್ದೇಶಕರು ಇರಬೇಕಾಗಿರುತ್ತದೆ. ಆದ ಕಾರಣ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಸಲ್ಲಿಸಿದಾದ ನಡವಳಿಕೆಗಳನ್ನು, ಡೆಲಿಗೇಟ್ ಫಾರಂಗಳನ್ನು ದೃಢೀಕರಿಸಿರುವುದಿಲ್ಲವೆಂದು ಹಿಂಬರಹ ನೀಡಿದೆ. He refuses to countersign on the ground. According to him, there is no quorum for that meeting.
What is the provision regarding quorum?
Forum is 14(a)(k).
14(a)(k).
Rule 14(a)(k).
AK2. AK2. Rule 14(a)(4), my lord.
Number next to 50% of the strength of the board, maybe 212.
Yes. %50 of the strength of the board.
Number next to 50% of the strength of the board.
Now, what is the strength of the board as per the bylaws?
As per the bylaw, it is 13, 12 plus 1, 12 elected directors, one representative of the financing bank. According to us, financing bank has not nominated any representative till now. So effective strength was 12. Out of that, 2 persons have died. Now, my lord,
Now, does it mean a working strength or a sanction?
for that, my lord, the lordship may kindly have. Of course, it's not under the Cooperative Societies Act. Cooperative Societies Act. It is under the erstwhile, it's under the Jilla Parishad, Taluk Panchayat and Nyaya Panchayat Act, Gram Swaraj, present Gram Swaraj Act. Question was, there was a no confidence motion moved. There were 3 vacancies in the board. Therefore, what is the strength for passing the 2/3? What will be the 2/3 for the purpose of removal? As the controversy was there, matter was referred to full bench. Kindly turn to 3778.
At page?
3778. A judgment nalledu. Left hand side.
Head note, yes.
Head note alla. Adad nantra. It's also within the head note itself. I just wanted to point out that number.
Opinion of the full bench.
Adralli question 2 may kindly be seen.
Yes.
In so far as the expression total number of members used in section 47 of the Act is concerned, either for the purpose of calling for a meeting or for the purpose of passing a resolution, it will only mean the number of members fixed under section 5(1) and nominated members, if any, under section 5(3) of the Act, minus the vacancies that may have arisen on account of death, resignation, disqualification, non-filling of the vacancies. Justice Hakim and Justice Rajendra Babu took the view it is the available effective strength on which number will have to be counted. And Justice Shivshankar Bhatt took the different view. I would, for the purpose of just reference, my lord, your lordship may kindly go to Kendra Purti. 28. राजेंद्र कपूर बिल शुरू हो गई थी. Your lordship may kindly turn to page 3806, my lord.
Yes.
That's the opinion of Justice Rajendra Babu. In that, next page, para 3, the remaining question.
Yes.
The remaining question raised in these petitions is, what is the meaning of expression total number of members in section 47 of the Act? Does it mean that the expression total number of members is what is fixed according to section 5(1) read with 5(3) of the Act after the whole procedure is gone through thereunder? Or does it mean total number of members existing or entitled to sit in the meeting at the time of consideration of the motion of no confidence, irrespective of whether they are present or not? The division bench decision in so and so has preferred the first of the views following the decision of this court referred to earlier. Learned counsel for the petitioner contended that decision in Sahib Gowda's case having been rendered keeping in view the scheme of various provisions of the enactment, having found the language thereof identical and having explained the concept of the total membership for the purpose of expressing no confidence in Pradhan Upapradhan does not require any reconsideration. After I prepared the draft of my view, learned brother so and so expressed disagreement with the same. I have the greatest respect for his views, and so I reflected over the matter again, but I regret my inability to agree with him. The scheme of the act with reference to matter in issue is as follows. Subsection 1 of section 5 provides that Mandal.
Para 7.
Yes, ma'am. A further analysis of the matter would further strengthen this view. The provisions relating to quorum and majority required for motion of no confidence is with reference to the membership of the panchayat, which is not static but varies from time to time, depending upon whether there are any backward class members or not, or whether any member was elected from two constituency or not, and on death, resignation, disqualification may lead to a number ceasing to be so thereof. The constitution of the panchayat peculiar in this regard, and that at no given moment of time can it be said that it is composed of a definite number of members. A member who belongs to a backward class, if he has been elected from a general constituency, represents two interests, and in which, as required under section 5(3) of the Act, a member may have been elected from two constituencies and for a period may hold both seats.
Yes, what do you say?
My lord, may I read once again the rule 14 AK4, my lord? That's what it says. That judgment is not relevant to this case, my lord, because the rule itself says and bylaw says that what constitutes quorum? Quorum constitutes that is a 7. 7 should be there. I will read that, my lord.
It is
Without seeing the bylaw.
Strength of the board.
Strength of the board, my lord. May I read, my lord? The number of next to 50% of the strength of the board, as specified in the bylaw, shall form a quorum. For a meeting of the board, the number of who are all attending the meeting shall sign the book kept for the purpose of before commencing the board meeting. If there is no quorum at the time of transaction, any business in any meeting of the board, no such business shall be transacted.
Let us see, let them, we'll make it subject to the outcome and we'll consider it.
That is one aspect. Second aspect is, my lord, they bring in ARCS,
Lord, may
Assistant Registrar of Cooperative Societies, to countersign. That is something which is not provided under Act rules or anywhere. He is some authority who says, I will not countersign it. As if he decides whether I should vote or not, or whether I should be there or not.
Lord,
It's
one
not,
request, Lord. Lord, may I request?
As this thing permissible. I am instructed to submit. This has been brought in by some circular issued by the election authority saying it should be in this prescribed form. It should be sent in this prescribed form. And that form says, confirmed by or approved by DRCS. That is not something part of the rule.
Lord,
of course, an argument is made that election authority under 39A has all the power for the purpose of conducting the election. Therefore, it includes plenary power. It is one thing to say under a constitutional provision, a commission is, election commission is constituted and certain powers are inherent is plenary. That's what it held in Ashok Kumar case and all. That is altogether different. In seeing, kindly see 39 capital A.
Rule or section?
Section.
39.
capital A.
Yes.
A very general election of the members of the board and election of the office bearers of a cooperative society, including any casual vacancy, to the extent applicable, shall be held under the superintendence of cooperative election authority. This superintendence, etc., is sought to be understood that it would include all the powers necessary for holding election. I would vote for that, but that would not permit them to introduce a new requirement, which is not there in the rule.
Lord, may I submit, my lord? This is the case where, my lord, the petitioner want to contest for the respondent society, that is, my lord,
They're
sixth respondent
sending a
society.
delegate.
DCC Bank.
They're
No.
sending a delegate.
He is a delegate to the sixth respondent society from seventh respondent society. That is one aspect. And another aspect is, my lord, if he has to be delegate from the seventh respondent society, there should be a transact of business took place when a meeting called. That is not taken place because there is no quorum.
No, now what is the quorum is a matter we'll have to examine.
Lord, my lord, that is a cleared thing, my lord, that is no need to ask any question about it, because if my lord sees the bylaw of the seventh respondent society, it is clearly mentioned in all the bylaws, it is a 7 is a quorum.
Where is the bylaw?
Bylaw they did not.
Put it.
produce.
That is bylaw 45, man.
Sub-rule 8, is it?
45,
8.
8. ಶೇಕಡ 50ರ ನಂತರದ ಸಂಖ್ಯೆ ಆಗಿರತಕ್ಕದ್ದು. Now, your lordship may kindly see the wordings of section 47 referred to in that decision. Your lordships get it at page 3789 in that judgment.
No, now this question of strength of the board is a matter that we'll have to consider. Let us see.
Ultimately, in that judgment, what was held was, if a interpretation is given that it should be 2/3 of the strength prescribed, then at a given moment of time, it is less than the available number of members itself is less than 2/3. Does it mean that there will be no confidence motion? There will be no functioning of the panchayat? That was the view taken.
Let us see. It's a matter for consideration.
I agree, my lord.
It's subject to the outcome.
My lord,
Whether the strength of the board refers
Lord-
to sanctions.
My lord, may I request, my lord? The supreme power of the board, no one has a power to exercise the power of the board until unless it is statute provides, my lord. And even this court cannot accept something or approve something which is not approved by the board itself. That one, it may be.
That interpretation of what is the strength of the board is a matter that we'll see.
Lord, in other all bylaw, it is a 7. but I don't know, I will look into it, this, my lord.
No, it says 50%.
No,
Next to 50%.
in all the bylaw, MPCS and Milk Producer Society, it is a 7, but this is something, it's a different bylaw.
Well, they have used the word rule 14 AK. Same word is used.
The senior counsel appearing on behalf of the petitioners has submits that the order at the endorsement at Annexure C,
Annexure E, man.
Annexure E is based on a false premise that quorum refers to, is to be calculated on the basis of the sanctioned strength. Can we use the term sanctioned strength?
Not elected strength. One is
Sanctioned
sanctioned
under
strength
the bylaw.
under the bylaw.
Sanctioned strength under the bylaw, but quorum ought to refer to the quorum should be calculated on the basis of available members, excluding those who are dead in the present case. In light of the said contention, as also the contention that question of certification by an officer of the cooperative department is not contemplated under the rules, it is submitted that Annexure E requires to be stayed. Subject to further consideration, there would be stay of the endorsement at Annexure E. It is needless to state the process subsequent to the interim order would be subject to orders to be passed before by this court.
Your Lordship, may kindly add another 2 words, my lord. Because of his endorsement and filing of writ petition, the date for submission of the delegate form, last date for submission of delegate form is over, that is 10th. Therefore, in the interim prayer, I have asked to allow the petitioner to, or your Lordship may permit that the delegate form may be accepted subject to result of the petition.
My lord, may I request one, my lord? If annexure is stayed, it doesn't make any difference, my lord. The very crux of the matter is whether his delegation is accepted or not. That is the question arisen here, my lord. If this court says that is accepted, then it is as good as final order.
For accepting
Final order.
Again, it will go to election officer.
It will be final order.
There will be a statutory officer will consider.
There is
Now, because of non-certification, I am not allowed to submit it at all.
n number of judgment. The final order cannot be granted at the stage of interim.
But why did you come late?
It was issued on your Lordship may kindly see on 7/3. We have filed it on 12th. In fact, we tried to explain it to the election authority, pointing out this may not be permissible for ARCS to do, but none of them were able to take a decision. Not that they were against me or for me. None of them were.
There is a 8-member, my lord.
When was this communicated?
ಇಲ್ಲ ಅವ್ರ ಅವತ್ತು ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಅವತ್ತೇ ಇರ್ತಾರೆ, ಅಲ್ಲೇ ಇರ್ತಾರೆ.
ಇಲ್ಲ
ಅಲ್ಲಿ ಮೀಟಿಂಗ್ no, ARCS is not the part of meeting, but the present petition is a part of meeting. He knows that day there is no quorum. There is no other members are supported him because they doesn't want to support him. Because of that reason, they took a leave on that day. They did not chosen to appear meeting. Quorum constitute ಆಗತ್ತಂತ.
The nomination by way, the nomination.
Delegation.
Nomination of the delegate.
ಇಲ್ಲ ಡೆಲಿಗೇಷನ್ ಅಂತಾನೆ ಅದು. ನಾಮಿನೇಷನ್ ಡೆಲಿಗೇಷನ್.
The
delegate form.
So you nominate a delegate, isn't it?
We elect a delegate.
Elected.
We elect a delegate.
As per
Annexure D1, as per resolution Annexure D and the form D series. We are required to submit it in 4 set. D1, 2.
No, he will not elect the delegate. Delegate will be elected by the 7th Response Society.
Seventh respondent has elected me as a delegate. That is the resolution.
ಕೋರಮ್ ಇಲ್ಲ ಅಲ್ಲಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿಲ್ಲ ಅದು ಸಮಸ್ಯೆ ಇರೋದು ಅದಕ್ಕೆ.
No, that is a matter for
Ah.
interpretation. Now, where is the resolution at?
Resolution is at annexure D. Typed copy at page 24. Original is at page 20. Page 24 typed copy.
Yes. Now, who is to take note of this?
We submit it to the DCC bank, who in turn submit it to the election officer, district election officer.
But it will
So
be.
this resolution has been submitted or not?
No, it has to be accompanied by the form at annexure D1, your lordship may kindly see.
D1 has been prepared.
It is prepared by the society. We prepare, society along with my photo, identity card, everything. It is prepared and it was submitted to the Assistant Registrar of Cooperative Society for confirmation or dhradikarana.
Yeah, stop.
He refuses to do it.
Further, the resolution at annexure D along with the prescribed form at D1 to be permitted to be forwarded by
The petitioner to the DCC bank, that is respondent number
permitted to be
6.
forwarded by the petitioner to respondent number 6 to be taken note of for the purpose of
Seventh response society ಕಳಿಸ್ಬೇಕು ಸ್ವಾಮಿ, ಅದು ಅವರಲ್ಲ. ಅವ್ರಿಗೆ seventh response society will send to the sixth response society. The delegation will be sent by the primary society to the secondary society saying that I have nominated from my society, there is one person named as petitioner.
That is the form.
process.
That is the form annexure D1.
now that has to be sent by whom now?
By
will
the
be
seventh
sent.
response society.
Now that I am elected as delegate and I want to participate, I will carry it and give it to DCC bank.
That is the 7th.
So, sixth respondent. Sixth respondent.
Again, but is there a last? To be taken note of for the purpose of the election process. Full stop. Needless to state, all consequential proceedings are subject to the outcome of this petition. AGA accepts notice for respondent 1 and 2.
1 and 2, 4 and 5, my lord. 4
and
to 1 to 1 and 2, 4 to 5.
4 and 5. Learned council.
3 for Kiran Kumar.
Kiran Kumar.
TL Kiran Kumar for 6.
6 and 7, no, emergency.
6
For
and 7.
6 and 7, in addition, your lordship may kindly permit hand summons.
Emergent notice to 6 and 7. Petitioners at liberty to take out notice by way of hand summons.
Please.
Lord, one more request, my lord, that maybe his delegation, if it is accepted, then it may be subject to the outcome of this writ petition.
That I want.
8.
Hand delivery, my lord.
It will be uploaded.
Kindly pass over. Serial number.
You want Passover in it?
8.
Passover.
9. Last week.
Lord's petitioner and my lord's respondent number 5. Jointly, my lords established a partnership firm.
But the loan was taken by the firm when you
Firm,
were
my lords. But my lords,
undivided.
fact remains, my lords, I was relieved from the partnership firm. May I request my lords to turn to page 77.
No, but what was the date of the loan?
Loan is in the year, my lords, 2017, 16 or 17 minutes. They undertook to clear that loan. My lords, except these 2 apartments, my lords, rest I am not challenging.
only 2 apartments which is allotted to my share, even under a registered partition deed. And my lord, subsequent MOU. And subsequently, my lords, I have been relieved from the partnership firm also. I have produced those materials also. Let the auction go on insofar as other properties. Lords, here is a case where, my lords, they undertake. I forgo all my lord's rights. They say, my lords, in order to.
But then that is an internal dispute between you
That,
and
but in the moment, if, my lords, my apartment is auctioned,
you have only right to reclaim from him.
my lords, tomorrow if third party interest is created, my lords, I will be nowhere.
Anyhow, auction is on 18th.
Auction is on 16th,
On
18th.
18th. You serve it, we'll have it on
Only one day, my lords.
Friday. We'll have it on Friday.
Please,
Imagine AGA accepts notice.
For 1 to 3, my lord.
Correspondent, 1, 2, 3. Emergent notice to 4.
4 to 8.
To 8.
Now, for the present, my lords, may I request my lords to defer, my lords, issuance of notice to respondent number 5 to 8, my lords.
No, let it be there,
Yes,
but we'll still consider.
yes.
The petitioner is at liberty to take out notice by way of hand summons for respondent 3 and 4.
Yes. May I make this request?
3 and 4. The consideration of interim prayers kept open. This is the matter on 15th.
In fresh matters
Yes.
list on. In fresh matters list on.
In the same stage.
May I make this request, my lords? Instead of hand summons, my lords, I may be permitted to serve on them, my lords, R3 and R4. Otherwise, office will take, my lords, one date, so that it will take.
Hand summons badlo, petitioner is also permitted to, in addition, petitioner is also permitted to intimate through
Respondent 3 and
to
4.
his counsel to respondent 3 and 4 regarding the matter being listed on 15th. Such communication should be accompanied with the extract from the website showing the status, case status.
Yes.
Then, put your order, serial number 10.
The petitioner,
No, but the cancellation of the residential certificate has to be challenged separately.
that also a challenge.
That is in different proceedings.
No, there is no order. That letter itself is according to them the order.
What are the facts?
Please, my lord, your lordship may kindly see. This petitioner, from the time of his ancestors, at least for the last 100 years, is the resident of Kondavadi village. There is a milk producer society, a primary society, of which he is a member. In turn, he was also elected as a member of Tumkur Milk Union for the last 2 terms. This village comes in Madhugiri Taluk.
You can be a part of 2 society.
No, it's not 2 society. That's a federal society. From primary society, I was also elected to the milk union. Then the petitioner, he became a little too ambitious for his shoes. He outgrew his shoes. He sought for ticket from Congress party from a reserved constituency. For that, he sought for his voter list to be shifted to another taluka within that constituency. Ultimately, he was not given the ticket, and the ticket was issued to someone who became the minister for cooperation for his bad luck. Then all of a sudden, several things started. Your Lordship may kindly see page 57. This is first notice saying, we have come to know that you are not a resident of this village. Therefore, you are not eligible to be a member of primary society. And therefore, under section 17, why you should not be removed. For that, reply, etc. was given.
Now, he's a member of that society since
2008 of this respondent number 4 society from
2008 annexure A.
Kindly see page 32 annexure A.
Two
2008 ನಿಂದ ಇದ್ದಾರೆ.
So for the first time in 23,
this happened. I replied to it, referring to several documents which presently may not be necessary to be shown, my lord. Then, without any reference or hearing, an order of disqualification was passed. Page 100, Assistant Registrar of Cooperative Societies passes the order at annexure K, page 100.
Now, what is the procedure for disqualification?
Under section 17, my lord, notice and an inquiry is contemplated. We made against that order, there is an appeal provided. I preferred the appeal. My appeal and my application for interim order was not taken up, which resulted in my filing a writ petition before this court. Writ petition was page 127. This honorable court was pleased to grant the interim order. Ultimately, writ petition was allowed to the extent that let the appellate authority pass the order within such and such a time on application or at least on the main matter. That is page 130. I had the benefit of an interim order of stay. Then, in the appeal, now the kindly see page 115. Annexure M. ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ತಾವು ನೋಡಬೇಕು. ಕುರುವರ ಹೋಬಳಿ ಕೊಂಡವಾಡಿ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಬಿನ್ ಕೆಂಪಣ್ಣನವರಿಗೆ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡುವ ಬಗ್ಗೆ ನೀವುಗಳು ಶಿಫಾರಸು ಮಾಡಿದ್ದು, ಈ ವಿಷಯವಾಗಿ ಮಾನ್ಯ ಸಚಿವರು ಹಾಗೂ ತಹಸೀಲ್ದಾರರವರು ಈ ಗ್ರಾಮದಲ್ಲಿ ಅರ್ಜಿದಾರರು ವಾಸವಾಗಿಲ್ಲದಿದ್ದರೂ ನೀವುಗಳು 45 ವರ್ಷಗಳಿಂದ ವಾಸವಾಗಿರುತ್ತಾರೆಂದು ಸದರಿ ಅರ್ಜಿದಾರರಿಗೆ ನೀವುಗಳು ವಾಸ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಈ ರೀತಿ ನೀವು ತಪ್ಪಾಗಿ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಿರುವುದು ನಿಮ್ಮ ಕರ್ತವ್ಯದಲ್ಲಿ ಬೇಜವಾಬ್ದಾರಿ ತೋರಿಸಿರುತ್ತೀರಿ. ಆದ್ದರಿಂದ ನಿಮಗೆ KCS ನಿಯಮ ಇದರ ಪ್ರಕಾರ ಶಿಸ್ತು ಕ್ರಮ ಯಾಕೆ ತೆಗೆದುಕೊಳ್ಳಬಾರದು. ದಿಸ್ ಈಸ್ ತಹಸೀಲ್ದಾರ್ ಇಶ್ಯೂಸ್ ಇಟ್ ಟು revenue inspector as well as VA. This immediately starts the proceeding by the revenue inspector, VA, etc. ಅದರೊಳಗೆ
Now what is happening now?
ಒಂದೇ ನಿಮಿಷ ಇನ್ನೊಂದು ಶಬ್ದಗಳನ್ನು ನೋಡ್ಬಿಡ್ಬೇಕು. ಪೇಜ್ 126 ತಾನು.
Yes.
ನಾನು ಆ ಊರಿನಲ್ಲಿ ಇರೋದು ಡೌಟ್ಫುಲ್ ಅಂತ ಹೇಳಿ ಎಲ್ಲ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ VA. ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ನೋಡ್ಬೇಕು. ಅರ್ಜಿದಾರ 1ರಿಂದ 8ನೇ ತರಗತಿಯವರೆಗೆ ಶಾಲಾ ದೃಢೀಕರಣ ಪತ್ರಗಳು, ಪಾಸ್ಪೋರ್ಟು, ವಾಸದ ಮನೆ, ವಿದ್ಯುತ್ ಬಿಲ್ಲು, ಜೀವ ವಿಮಾ ಪಾಲಿಸಿ, ಗ್ಯಾಸ್ ಬಿಲ್ಲು, ಮತದಾರ ಪಟ್ಟಿ, ಪಡಿತರ ಚೀಟಿ, ಆಧಾರ್ ಕಾರ್ಡು, ಗ್ರಾಮಸ್ಥರ ಮಹಜರು, VA ಇವರು ನೀಡಿರುವ ವರದಿಯನ್ನು ಲಗತ್ತಿಸಿ ತಮ್ಮ ದಯಾಪರ ಮಾಹಿತಿಗೆ ಸಲ್ಲಿಸಿದೆ. ಕೈತಪ್ಪಿನಿಂದ ವರದಿ ನೀಡಿದ್ದು, ಇನ್ನು ಮುಂದೆ ಇಂತಹ ಪ್ರಕರಣಗಳನ್ನು ಖುದ್ದಾಗಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ವರದಿ ನೀಡುತ್ತೇನೆಂದು ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. ಇವನ್ನ all this is sought to be done without notice to me, and they are supposed to have passed the order. Annexure Q1, page 138. Deputy Registrar writes a letter to the Tahsildar, 27/11/23, page 138. ವಾಸ ದೃಢೀಕರಣ ಪತ್ರ ನೀವು ಹ್ಯಾಕ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಇದರಲ್ಲಿ ಅವರು ತುಮಕೂರು ನಗರದಲ್ಲಿದ್ದಾರೆ, ಅಲ್ಲಿ ತುಮಕೂರು ನಗರದಲ್ಲಿ 2 ಕ್ಲಬ್ಬಿನ ಮೆಂಬರ್ ಇದ್ದಾರೆ. ಐ ಆಮ್ ರಿಯಲಿ ವೆರಿ ಅಫ್ರೈಡ್ now that Deputy Registrar of Cooperative Society will go to clubs to verify membership. ಎಷ್ಟು ವರ್ಷಗಳಿಂದ ಇದ್ದವ್ರಿಗೆ ನೀವು ಹ್ಯಾಕ್ ಕೊಟ್ರಿ ಅಂತ ಹೇಳಿ ಅವರು ಈ ಲೆಟರ್ ಕಳಿಸ್ತಾರೆ 27/11/23ಗೆ. ಅದಕ್ಕೆ ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ ತಹಸೀಲ್ದಾರ್ ಬರೀತಾರೆ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರಿಗೆ ಪೇಜ್ 140. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇ ಕೈಂಡ್ಲಿ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಚಂದ್ರಶೇಖರ್ ಬಿನ್ ಕೆಂಪಣ್ಣರವರು ವಿವಿಧ ವಿಳಾಸಗಳಲ್ಲಿ ದಾಖಲೆ ಹೊಂದಿರುವುದು ಸಂಶಯಾಸ್ಪದದಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೇಲೆ ತಿಳಿಸಿದ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದ ಈ ಕಚೇರಿಯಿಂದ ನೀಡಿರುವ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರದ ಸೋ ಅಂಡ್ ಸೋ ರದ್ದುಪಡಿಸಲು ಕೋರಿ ದಾಖಲಾತಿಗಳನ್ನು ಲಗತ್ತಿಸಿ ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರಿಗೆ ಕಳಿಸ್ತಾರೆ ತಹಸೀಲ್ದಾರ್. I make an application to the Assistant Commissioner whether such a application is received, what is the order passed, it's a report is received, what is the order passed. Till date, no copy was issued. On the other hand, a endorsement is issued, page 142.
Now this cancellation of the residential certificate you have separately challenged and got a stay.
No.
In this
There is no order. Only thing that is available is this communication at Annexure X. Page 159 RTI Act ನಲ್ಲಿ ನಾನು ಅಪ್ಲೈ ಮಾಡಿದೆ. 160 is the order, supposed to be the order. ಚಂದ್ರಶೇಖರ್ ಬಿನ್ ಕೆಂಪಣ್ಣ ಆದ ನೀವು ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ವಿಷಯದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಕೋರಿರುವುದು ಸರಿಯಷ್ಟೇ. ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ನಿಮ್ಮ ಮನವಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಪ ತಹಸೀಲ್ದಾರ್ ಅವರ ಆದೇಶವನ್ನು ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಿ ನೀಡಲಾಗಿದೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಿ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ 160. This is not addressed to me, not communicated to me. It is sent to the Deputy Registrar of Cooperative Societies. And apart from this, there is no other order. He says we have cancelled. Annexure X is the communication.
Now what has happened to the proceedings before the?
Now the DRCS says, I have received the letter at Annexure X. He leaves the reasons given by the original authority. He says, Now that the residence certificate has been cancelled, I dismiss the appeal. Page 135, annexure Q. Relevant portion would be page 137. About 5 lines from the top. He says, I sought for report from the revenue authorities. 5ನೇ ಲೈನ್ 27/11/23 ತಹಸೀಲ್ದಾರ್ ಮಧುಗಿರಿ ತಾಲೂಕು ಮಧುಗಿರಿ ಇವರನ್ನು ಕೋರಲಾಗಿದ್ದು ತಹಸೀಲ್ದಾರ್ ಮಧುಗಿರಿ ತಾಲೂಕು ಇವರು ಸಲ್ಲಿಸಿರುವ ಸ್ವಯಂಸೋ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡುವ ವಿಷಯವಾಗಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಗ್ರಾಮ ಆಡಳಿತಾಧಿಕಾರಿಗಳು ವರದಿಯೊಂದಿಗೆ ಮೇಲ್ಮನವಿದಾರರ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿರುತ್ತದೆ ಎಂಬುದಾಗಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರು ಸಲ್ಲಿಸಿರುವ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರವು ಅನೂರ್ಜಿತವಾದುದರಿಂದ ಮೇಲ್ಮನವಿದಾರರು ಕೊಂಡವಾಡಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಲ್ಲಿನ ಕಾಯಂ ನಿವಾಸಿಯಾಗಿರುವುದಿಲ್ಲ ಎಂಬುದು.
Matter requires consideration.
My lord, may I request, my lord?
Of course, my lord, just to not to make it an issue at this, earlier we had actually made the honorable minister also as a party, but presently we have not done that.
No, that is not a issue, my lord. That is only they come before this court. I'm saying that the appellate authority has not considered interim application in time. That was the petition made before this court in earlier occasion, and this
Correct,
court
but-
has directed.
Now, the appellate order is in question.
Appellate order is, no,
No,
the rejection of interim order is questioned now, my lord.
ಇಲ್ಲ, ಇಲ್ಲ. Final order.
Final order.
Final ಮಾಡಿ.
That is one aspect.
Page 1. So then we'll have to consider it. 106, order is in question. We'll consider it. In light of the contentions raised, matter requires consideration. Subject to further consideration, there would be stay of the order at annexure Q.
Q, K and X.
At annexure Q. Annexure, as well as order at annexure K. K is the original order,
K is the original order.
but X you will have to separately see. Q and K is this part of this proceeding.
Of course. No, X also I sought for quashing.
Right, but X is proceeding.
Before the
that
revenue
will be on the revenue side, I
Revenue
don't know. Though it may be connected. So insofar as Q and K will stay.
Please,
Q and K. X you will have to separately say.
I will file a petition and thereafter withdraw that prayer.
Yes. Q and K.
I may be permitted
The
to
rest-
file a
AGA.
vacating application.
AGA is permitted, accepts notice for respondent 1, 2, 3.
1, 2, 3, 5. 5 to 10, my
1, 2,
lord.
3,
1 to
5,
3, 5
6.
to 10. 5 to
5
10.
to 10. 5 to 10. What about 4?
Four,
Emergent
you
notice to
me direct
respondent.
emergent notice and permit me
Petitioner is
to,
permitted to take out notice by way of hand summons.
please.
Respondents are liberty to seek for modification of interim prayer upon filing statement of objections. But suddenly after 20 years, he cannot become state.
My lord,
I
may I
have
re-
my
no,
house,
no, no, no,
everything
my lord,
there.
may I request, my lord? There is a
And-
change in his residence. He changed it to other society. The Cooperative Act, it mandates that the area of operation is very strictly operated. Because of that reason only, the members who are situated in the area of operation of the so-and-so society has to enjoy the benefit. As someone who is staying outside the benefit, and he cannot take two benefits, like he cannot take a benefit which is granted to the Tumkur city, and he cannot take a benefit which is granted to the society which is concerned. Because of that reason, the area of operation is very limited purpose.
Let us,
So if he is not resident of that area of operation, then he will lose.
all your MLAs from North Karnataka stay in Dollars colony. No?
ಅಲ್ಲ ಅವ್ರು ಯಾಕೆ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
That will not up.
No,
In
it is in respect of the primary society, my lord. Kindly see the object of primary society. It is made for only farmers. It is made for only farmers.
ಈ ಸೊಸೈಟಿ ಬಿಲ್ಡಿಂಗು ನಾವು ದಾನ ಕೊಟ್ಟು ಜಾಗದಲ್ಲಿ ಸೊಸೈಟಿ ಬಿಲ್ಡಿಂಗ್.
Let us,
ದಾನ ಕೊಟ್ಟಿರಂದ್ರೆ ಅವ್ರ ಮೆಂಬರ್.
Let us see.
11. Vinay H.
ಅಂದ್ರೆ ಮೈಸೂರು ಅರಸರು ಬಂದ್ಬಿಟ್ಟು.
Kindly pass forward.
Password, please. Password.
12. Serial number 12, Vijay Kumar. Petitioner my lord.
And so petition filed by the wife. Wife is staying in Mysore along with the children and a child, girl child, who is aged around 6 years.
Service completed.
Service has been completed.
You also served it on the council.
Yes, my lord.
Memo you have filed.
I have filed the memo.
From where to where?
From Harihara to Mysore.
Harihara to?
Mysore.
What is the distance?
350, my lord, for kilometers. From Mysore to that. So up and down it is around 700 kilometers.
Any children?
One baby girl.
You are working or?
Yes, my lord. I am working as in KSRTC.
KSRTC. Where?
Mysore.
Presently. Respondent is?
Respondent is also an employee of KSRTC, but he is staying in Harihara.
The petitioner wife has sought for withdrawal of proceedings in MC 17 of 2020 instituted by the respondent and pending consideration before the court of the senior civil judge and JMFC at Harihara, and sought for transfer of such proceedings to the family court at Mysore. The respondent, though served, has remained absent. Counsel for the petitioner has also filed an acknowledgement for having served copies of the petition on the counsel appearing for the respondent in the trial proceeding.
Before the trial.
Next, the petitioner submits that she is an employee of the Karnataka State Road Transport Corporation and presently working at Mysore. Full stop. It is submitted that from within the wedlock, there was a child who is aged about 6 years and traveling from Mysore to attend proceedings at the court at Honnali.
Honnali.
Court at Honnali seriously inconveniences the petitioner in light of the distance to be traveled and also
Harihara.
Harihara. And also in light of the child of tender age who cannot be left alone if the petitioner were to travel to attend proceedings before the court at Harihara. Next, the inconvenience pleaded on such grounds of travel as well as regarding looking after the girl child of tender age who cannot be left alone if the petitioner were to travel remain uncontroverted. This court in MB Rekha's case has observed as follows. Accordingly, convenience of the wife requires to be taken note of. In light of the facts as made above, case is made out to allow the petition, and accordingly petition is allowed. Proceedings and so in MC 17 of 2020 are withdrawn and directed to be transferred to the family court at Mysore. Necessary records to be transmitted.
13, Mohan BK.
For petitions, my lord. My lord, in this case, I have sought the transfer of the petition from Virajpete to Mysore, my lord. From Virajpete to Mysore, my lord.
I am for the respondent. Praise 2 weeks time because he is not in India.
Virajpet to Mysore.
Mysore,
my lord. Mysore, my lord. The wife is having 2 children, my lord, young children, my lord. And
what
she is
objection-
staying alone with the two children.
Just 1 minute, what
Confirm,
objection you have?
No, because they
For
made.
transfer petition, what objection?
I will have to seek certain instructions.
No,
He is
no.
not in India.
No, correct, I'm saying.
Hello, one. Short accommodation, I will.
Relist the matter in the same stage. On
1 week at least, 1 week.
20th.
Obliged, my lords.
14. Ajay Prabhu M. Joseph Anil Kumar A.
Wife's
Appearing
petition,
for
my lord.
respondent.
Wife is seeking for transfer of petition. Divorce petition filed by the husband from Bangalore to Puttur, my lord. It's 350
Bangalore
kilometers.
to,
Puttur,
what is the distance?
350 kilometers, more than 350 kilometers.
350.
Yes. She's having a 8-year-old child. Was joined school in Puttur.
She's working.
Lordship, she's working for purpose of son who is joined the school. She's having, my lord, 5,000 to 7,000 income.
She's working where?
In Camco, some small job, my lord, temporary job.
Yes, madam.
Your lordship, petition will be allowed with liberty to respondent to appear through video conference for recording of evidence.
The petitioner. Wife has sought for transfer of the proceedings in MC 4783 of 2023 as instituted by the respondent husband seeking dissolution of the matrimonial proceedings pending before the principal judge family court at Bangalore. To
Senior Civil
The-
Judge Puttur, my lord.
designated family court at Puttur.
Please.
Full stop. The petitioner admittedly stays at, is a resident at Puttur, which fact remains uncontroverted. The distance to be travelled for the petitioner to attend proceedings before the family court at Bengaluru from her residence would involve travel of about 350 kilometers. Any children? No.
Yes, my child,
Huh.
8-year-old child.
Son.
It is
One
further
Son.
made out that from within the wedlock, the petitioner and respondent have a child who's aged about 8 years staying with the petitioner. And that if the petitioner were to attend proceedings before the court at Bengaluru, there would be difficulty in looking after the child if left alone at Puttur. Full stop. Inconvenience is also pleaded on the ground that the distance is such that the petitioner may have to stay overnight at Bengaluru. Full stop. In light of this court in the case of MB Rekha is held as follows. Accordingly, the convenience of the wife requires to be taken note of and given precedence in such matters. In light of the admitted facts regarding distance of travel and also the requirement of petitioner looking after a child who's aged about 8 years, the plea of inconvenience requires acceptance. Accordingly, petition is allowed. Proceedings in MC so and so are withdrawn from the family court at Bengaluru and transferred to the family court at Puttur. Next, third counsel for the respondent submits that the court to which proceedings are transferred ought not to insist on physical presence of the respondent on all dates, and that to the extent possible, the court may have recourse to proceedings through video conference in light of the video conference rules framed by this court. Next, such submission by the counsel for the respondent deserves acceptance. In light of the video conferencing rules, the court to which proceedings are transferred must make effort to ensure that the respondent is permitted to attend proceedings through video conference as well, except where physical presence of the respondent is required. Full stop. It is also made clear that mere lack of infrastructural facility or network problem cannot be a ground to refuse opportunity for the respondent to make use of video conferencing facility. Full stop. Accordingly, subject to such observation, petition is disposed of. Copy of this order also to be sent to the Principal District Judge, Udupi. Huh?
No, it is Senior Civil Judge
No,
Puttur.
no. Who's the administrative head? Which district it?
It is belong to Mangalore, my lord. That's
Mangalore.
Kannada.
Puttur.
Principal District Judge Mangalore to ensure that video conferencing facility issues are sorted out.
Please.
Accordingly, petition disposed.
Oblige.
Much obliged.
15, Manjunath PS.
Hearing for the respondent in this matter.
It's wife's petition. Both husband and wife and working in Bangalore. Despite that, the husband files a petition in Athani,
Both are working at Bangalore.
But he files a petition in Athani where she has to travel for more than, overnight travel is there more than 12 hours and the journey is.
What is the distance?
Near about 700 meters.
Any children?
No children.
No children.
She's working.
Both, yeah, she's working in Bangalore and he is also working in Bangalore.
It might be transferred.
The petitioner wife. Shall we say by consent?
By consent, please.
The present petition is filed by the wife seeking transfer of proceedings. Seeking withdrawal of the proceedings in MC 12 of 2023 instituted by the respondent husband seeking dissolution of the matrimonial relationship pending before the Principal Senior Civil Judge at Athani and for transfer of such proceedings to the family court at Bengaluru. At the time, full stop. Counsel for the petitioner submits that travel from Bengaluru to Athani would involve travel of about 700 kilometers, which as well as overnight stay, which would seriously inconvenience the petitioner. Counsel for the respondent fairly submits that as the respondent is also presently working at Bengaluru, the petition may be, suitable orders may be passed. Taking note of the inconvenience of the wife and also that the husband works at Bengaluru. Case is made out to allow the petition, taking note of the inconvenience of the petition. Accordingly, petition is allowed, proceedings in so and so are withdrawn from the court of Athani and directed to be transferred to the family court at Bengaluru. Necessary records to be transmitted forthwith.
Much obliged.
16, 17 urgent, serial number 18, Chandrakant Argal.
I appear for petitioner members. Petitioner is a wife. She filed a suit for restitution of conjugal right before in Chamrajnagar on
Is
2000.
residing at?
Chamrajnagar. Meanwhile, on 2023, the husband filed a suit for the dissolution of marriage in Mysore. So the petitioner herein is requesting to transfer the matter from Mysore to Chamrajnagar.
What is the distance?
70 to 80 kilometers. They have to travel for 2 hours since she have no source of income. She have no source of income. She
She's
can't-
working or no?
No, ma'am.
Any children?
No, ma'am.
Notice surviving. Huh? Rishma. The first time it's coming.
Please, ma'am.
In light of the contention, the petitioner is a dependent on her parents and traveling from her village at Hosuru to the court at Mysore would involve travel of about 80 kilometers which seriously inconveniences her and interferes with the right of fair trial, there will be stay of further proceedings in MC so and so till the next date. He is filed for restitution.
Please, my lords. I filed for restitution of conjugal right, and the husband filed for dissolution of marriage.
There would be in light of the petitioner having filed proceedings for restitution. You have filed at Chamrajnagar
Please, my lords.
before the court at Chamrajnagar, and the respondent husband having instituted proceedings for dissolution of the matrimonial relationship pending at Mysore to avoid passing of conflicting decrees. Both proceedings in MC 895 of 2023 pending before the Principal Judge Family Court of Mysore, as well as the proceedings in MC number
893 of 2023.
restitution one,
95 of 2023.
895 of 2022,
23.
page 16, you see,
My lords,
page 16.
that is the suit which is filed.
Correct, both will have to be stayed. So which is the number of your restitution proceedings?
MC 63 of 2022. 63 of 2022.
63 of 22, pending before the court of senior civil judge at Chamrajnagar would be stayed till the next date.
That's our apologies. By mistakenly, we didn't seek the interim prayer, my lords.
File.
First day.
I'll pass over. You file your application. You file with our memorandum of facts.
Please.
Pass over.
Respondent in this case, my lords.
The petitioner, my
I
lords.
undertake to file wakalat for respondent. May request 1 week's time to be granted, my lords.
What are the proceedings?
Petitioner wife, my lord, she has filed her divorce proceedings here in Bangalore. Respondent husband has filed a section 9 restitution of conjugal rights in Hassan. Petitioner is a student. She is studying here in Bangalore.
Hassan is MC number
281 of 2023.
and the restitution is 28 of.
My lord's restitution is 281 of 2023. Here, the divorce petition is numbered as MC 25 of 2024.
No, just 1 minute. Restitution proceedings in MC
281 of 2023.
This is pending before.
Hassan, Principal Judge Hassan, family.
Restitution is filed by
The husband.
Now you have filed for dissolution.
Dissolution of marriage here in Bangalore.
MC
25 of 2024.
at Bangalore.
Yes, my lord.
You are seeking for withdrawal of 281 to here.
Yes.
Now both have to be decided by the same court, isn't it? The restitution and
Next, have it next week, take instruction. Next week, maybe in the date may fix it and I filed wakalat and
Monday.
please. my lords.
18.
Deal is the matter in the same stage on Monday.
Very well.
Both will have to be consolidated.
Much obliged.
20. Till number 20, Akash Kumar.
Transfer of the case, my lord. The respondent has filed for the restitution of conjugal rights, my lord. I'm not able to travel, my lord, and I do not have the means also. Therefore, my lord, I'm seeking transfer of the case, my lord.
From where to where?
From Principal Civil Judge and CJM Mandya to Honorable Second Additional Principal Family Judge at Mysore.
What is the distance?
The distance is about 50 kilometers, my lord. Yakendre she has no other means to travel also.
But even for 50 kilometers we seek transfer, how is it?
And my lord, I've also filed a petition for maintenance, and that has been stayed. Other than that one, my lord, I do not, and my father is also very aged. So therefore, my lord, it is very.
He's not paying maintenance.
No, it's not paying. They have obtained stay. By filing a restitution of conjugal rights in that matter, my lord, they have obtained stay. And I do not have any other means. Therefore, my lord, it is very difficult for me.
The petitioner, wife, sought for withdrawal of the proceedings. ಇದು ಸರ್ವ್ ಆಗಿದೆ ನೋಟಿಸ್. Sought for withdrawal of the ಯಾವತ್ತು ಸರ್? No, just 2 weeks since he served with notice. We'll give one more adjournment. If he doesn't come, we'll.
Please.
Matters adjourned, granting an opportunity for the respondent to put in appearance. Release the matter on 21st.
My lord, there is a stay, my lord. Interim order may be extended. My lord.
Interim order earlier interim order in operation is extended till the next date.
Much obliged.
21 urgent, 22,
My lord,
A.R. Lingaraju.
I'm sorry, my lords, serial number 19, interim order is required to be extended.
19, interim order earlier granted is extended till the next date.
Sorry, my lords, that's okay.
21 urgent, 22, A.R. Lingaraju.
Respondent.
Yes, subject to appear petitioner, my lord. On earlier occasion, my lord, I suggest to the go before mediation center.
Seeking for transfer from
Chitradurga to
So
Assam.
no, last time it is, they have sought time for, take the instruction to refer the mediation at Bangalore.
My lord,
Petitioner. That
Yes,
is
they
why.
are-
Because there is an allegation by the, when earlier he filed a the MC petition,
may I make submission? My lord, this court suggest me to go for mediation. My lord, I contacted the advocate before trial court, my lord. Now the petitioner father condition is not good. He is counting his days, my lord. He is bedridden. Therefore, my lord, moreover, today morning she called me and informed me that
is not interested.
not interested to go on with the
Mediation.
no. The husband filed the divorce petition. She want to quit him, my lord. She
wants
said
to?
so. Divorce ready there.
She's ready.
Ready there. But because my lord, father bedridden ಆಗಿದ್ದಾರೆ. Maybe or this no survival rate is very less, my lord. ಈ ಟೈಮ್ ನಲ್ಲಿ ಇದೇನು ಆಗೋದು ಬೇಡ. ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳ್ಳಿ ಅಂತ. Otherwise, my lord, keep pending in this court or transfer the case to the Assam, my lord.
No, you file 13, just one. Now file 13B and close the matter.
See, my lord, ಫಾದರ್ದು ಕಂಡೀಷನ್ಸ್ ಮನೇಲಿ ಪರಿಸ್ಥಿತಿ ಸರಿ ಇಲ್ಲ. ಒಂದು 4 weeks ಆದ್ಮೇಲೆ ನೋಡೋಣ, ಇನ್ ಕೇಸ್ ಏನಾದ್ರು ಮೈಂಡ್ ಏನಾದ್ರು ಚೇಂಜ್ ಆಗಿ ಏನಾದ್ರು ಆಗ್ಬೋದು, ಮೈ ಲಾರ್ಡ್. ಲೆಟ್ ಇಟ್ ಬಿ ಆಫ್ಟರ್ 4 weeks, ಮೈ ಲಾರ್ಡ್. ಇಟ್ಸ್
Release the matter. Date ಕೊಡಿ after 4 weeks.
next month, after 4 weeks or 5 weeks.
ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲಿ.
Interim order earlier granted is extended till the next date.
Please, much over.
23,
Appearing for petitioner, my lord. In this case, wife filed the transfer petition, my lord. Husband filed the section 9 of Hindu Marriage Act before Chintamani. And also, my lord, the petitioner also filed an maintenance case before the Srinivaspura, my lord.
Just 1 minute, just. Now he has been served only last week. We'll give him
Yes, my lord, yes, my lord.
some more time for appearance.
Yes, my lord. Please, my lord, please.
The interim order earlier granted is extended till the next date for appearance of the respondent. This is the matter.
26th.
26th.
Please, my lord.
Yes.
Serial number 24. Abhishek A. Cyril Prasad.
For the respondent. For the petitioner, my lords.
Filed a petition,
Not
my lord.
keeping well, so kindly give an adjournment.
We have no objection, my lord, to transfer the petition from Bangalore to Bangalore.
Only one submission, my lord. There is a criminal miscellaneous case was filed. In that resident, he has got two houses, my lord. In one houses, it is a residential house, my lord. I was and we are staying together. The matrimonial house. That house, my lord, is kept it under lock and key. My clothes, my certificates, everything is in that house. I filed a criminal miscase, my lord. Court has directed for me to stay in that house. Now he has filed an appeal and obtained and stay. If the matter is transferred from Bangalore to Bangalore, my lord, I don't have a residence to stay, my lord. I'm earning only 25,000 and he is earning around 2,75,000 per month. This is the present scenario. My father is a heart patient, my lord, and mother is also housewife, my lord. If only one direction, my lord, let him open that house and allow me to stay in that house.
My lords, my senior is not keeping well. Any date may be given. My
We'll have it on Monday.
Yes, ma'am.
Release the matter in the same.
interim order may be extended.
same
My
stage on Monday. Interim order earlier granted is extended till the next day.
obligations.
25. Serial number 25.
Appear for the
Super
petitioner, my
please.
lord. It is a petition for transfer of a suit, my lord. I am the defendant in the suit. I am the third defendant. Right now, before your lordships, all the respondents are represented. I have also served to the trial court counsel. I am seeking transfer of the suit. It's a suit for partition. All the schedule, your lordship finds the schedule at page 20. Those from Magdi court, they are about 55 kilometers, while to city civil court, they are situated within a distance of about 15 to 18 kilometers. And parties are all senior citizens. It would be convenient that the trial is held in Bangalore, because the only purpose of filing it in Magdi was to see that I am inconvenienced. In fact, kindly see the cause title. All the parties are senior citizens. They are all admittedly residents of Bangalore.
Now, how many properties fall within the Magdi jurisdiction?
The
Magdi court.
Magdi court, my lord, there are out of 10 items of property, 6 items fall. In fact, those 6 items are all in the same village. The same village.
My lord, senior citizen, my lord. In Magadi is better, my lord. In out of city, my lord. In city ಬರ್ಬೇಕಾದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. Out of city, Magadi idre.
You appear for the
third respondent, my lord.
He is one of the defendants in the suit. He is the first defendant in the suit.
What about the other two defendants?
The other
has filed the suit, my lord. Kempamma. In 76 years age, my lord. In Bhimankuppe village. Ramholli. In Magadi, my lord.
He doesn't represent them. In fact, my case is that it is a collusive suit at his instance. That is my case. Of course, I am not on that.
In senior citizen, my lord. Magadi is better.
In fact, her residence is closer to city civil court than to Magdi court. And the learned counsel who has instituted the suit is in Ramnagar.
What is the stage of proceedings?
On the last date of hearing, that was on 7th, all the pleas are served. Now it is to file the written statement. Pleadings are not yet complete. In fact, they have an interim order in their favor not to alienate. I am suffering an interim order because it is an innocuous order because it's a partition suit.
Just think about it and have it next week.
My lord, in that case, till then.
All the others are also senior citizens.
Yes,
all of them, they are all siblings, my lord. All 4 parties are siblings.
Is there any possibility of any settlement?
That I will
inform. I will collect the.
Find out.
We'll find out.
We'll have it on Monday.
My lord, may I request for Wednesday, my lord?
Release the matter on next Wednesday in the same stage. You find out, if you are ready, I'll refer it for mediation.
Please.
The legal position is clear. So if you want to sort it out, you sort it out. Why subject yourself to a trial? If there's no dispute factually.
There are factual disputes because, and the nature of the properties is, my case is that some of my self-acquired properties are also arrayed as joint family properties. That's a factual controversy. And pleadings are not yet complete. That's the difficulty for me to put forward my case before the mediator.
Let us see.
Not a
But you find
self-occupied
out,
property, in joint family property, my lord.
that we'll see. We'll have it next week, you get instructions. Deal is the matter on so and so, in the same stage. But mere inconvenience cannot be a ground, anyhow we'll consider.
Of course,
let
it's
him-
not in, all the parties are in Bangalore only, that is.
But
admitted.
one person is at Magdi, he said.
No, my lord.
Bimankuppe,
That's also in Bangalore.
near in 30 kilometers, 25, 30 kilometers, my
In
lord.
fact, it is farther to Magdi than to
72
Bangalore.
years, my lord, 76 years.
That is also in Bangalore, kindly. Ramahalli is now in BBMP jurisdiction.
Let us see.
Yes.
Yes.
Seeking transfer from Bangalore to Puttur, my lord. Petitioner is the wife of the respondent.
What is the distance?
More than 350 kilometers, my lord. Even one more petition filed by the petitioner, my lord, at Puttur. I have placed before this court, my lord.
So you are seeking transfer of,
MC petition, dissolution of marriage.
that is 7164,
Yes,
from Bangalore to Puttur.
Puttur.
Which is other proceedings
MC number 6/2024, my lord.
for,
Also dissolution of marriage.
that is also filed for dissolution.
Yes, that is filed by the petitioner at Puttur.
For respondents at my lordship, may be allowed, my.
The present petition is filed by the wife seeking withdrawal of the proceedings in MC 7164 of 2023, instituted by the respondent husband pending before the family court at Bengaluru, and has sought for transfer of such proceedings to the court at family court at
Principal
at Puttur.
Senior Civil Judge and SCJM Puttur.
At Puttur. In the case of the petitioner, that she is a resident of Puttur and to travel and attend proceedings before the court at Bangalore would involve travel of about 350 kilometers, which seriously inconveniences her. It's further submitted that MC 6 of 2024 has been filed by the petitioner seeking for dissolution of the matrimonial relationship, which is pending before the court at Puttur. Learned counsel for the respondent submits in light of two petitions being filed for the same relief. They have no objections for transfer as sought for. Taking note of the relief sought for in MC 7164 of 23 and MC 6 of 2024, in order to avoid passing of conflicting decrees, both matters require to be consolidated and disposed of by the same court. Taking note of the inconvenience as pleaded by the petitioner in light of travel of about 350 kilometers to attend proceedings before the family court at Bengaluru. Taking note of such inconvenience and in light of the law laid down in MV Rekha versus so and so, the case is made out for allowing the transfer petition, and accordingly proceedings in MC 7164 of 2023 are withdrawn from the family court at Bengaluru and directed to be transferred to the court of the principal senior civil judge and ACJM at Puttur, wherein proceedings MC 2024, wherein MC 6 of 2024 is pending consideration. The proceedings in MC 7164 of 2023 upon transfer to be called along with proceedings in MC 6 of 2024 and be tried together. Accordingly, petition is disposed of.
Much obliged.
Lord, the matter may be kindly passed over, my lord. The advocate on record is held up in another court hall.
I filed my counter. Your lordship may kindly see. This is a young girl who, after a threat to life because she could not conceive for reasons that I have stated in the petition, in my rejoinder, has relocated to Bangalore. The marriage was registered. The couple lived as husband and wife before they went to Saudi in Bangalore. And now she's living in Bangalore. There's all documents have been produced. The question of transferring to Belgaum, Khanapur does not arise at all.
We'll have it tomorrow.
Much obliged.
Release the matter tomorrow in the same stage.
Please, for this wife is seeking transfer from Mysore to Hubli, my lord. Hubli, she has filed a restitution of conjugal rights petition. Together it can be adjudicated.
Opposite side. Can. Thank you very much. We'll give one opportunity. If
Please.
they don't come on the next date, we'll
Please,
dispose.
please.
Relist the matter in the same stage on 21st.
Stay may be extended.
Interim order earlier granted is extended till the next date.
Please.
Wife's petition seeking transfer of my lord. Divorce petition filed by the husband before Beltangadi court, my lord, to Udupi.
He's seeking transfer from?
Beltangadi to Udupi, my lord.
He has put in appearance last week. We'll give him some time to put in appearance.
Interim order may kindly wait.
Interim order earlier granted is extended till the next date. Time granted for appearance on behalf of the respondent. Relist the matter on 27th.
Please, oblige.
Appear for respond. Press for time.
At request made on behalf of the respondent. Relist the matter on next week date code
18.
20th.
18.
Interim order may kindly.
Interim order earlier granted is extended till the next date.
For petitioner, my lords, seeking transfer of petition from Ranebennur to Tarikere, my lords. The distance is about 157 kilometers. My lords, the petitioner has also filed another petition under Domestic Violence Act, my lords.
No, what is she has any children?
No, my lords, no children, my lords. She has no job, my lords. She has financial difficulty to travel.
In light of the submission that petitioner is required to traverse a distance of about 157 kilometers to attend proceedings instituted by the respondent husband pending before the court at Ranebennur. Subject to further consideration, there will be stay of proceedings in MC 107 of 2021 till the next date. Emergent notice. Petitioner is at liberty to serve counsel appearing for the respondent before the trial court.
Please.
32. Rajan.
Yes, sir. For petitioner. Wife's petition for transfer of from Punikal to Bangalore, my lord. She has also filed CMS before the family court, Bangalore, my lord, principal.
What is the distance?
Distance, my lord, 80 kilometers. She's illiterate and she has to be accompanied by someone else to go to.
She's working?
No, my lord. Only daily wages she works, my lord. And only 3,000 rupees is maintenance is ordered, and that too he is not paying regularly, my lord.
In light of the submission that petitioner is required to travel a distance of about 80 kilometers to attend proceedings instituted by the respondent husband before the family court at Kunigal. And also in light of the contention that the respondent is not paying,
Regularly, he is not paying, my lord.
is irregular in payment of maintenance. As a result of which petitioner finds it difficult to defend the proceedings instituted by the respondent husband at Kunigal. There would be an interim order of further proceedings in MC 95 of 2023 till the next date. Emergent notice, petitioner is present, permitted to serve counsel appearing for the respondent before the trial court, which would be in addition to notice through court.
Much obliged.
23, S.V. Prakash.
Wife petition, my lord, seeking transfer of MC petition filed by the husband, respondent, to the family court at Shumoga. My lord, the distance between Udupi to Shumoga, my lord, 200 kilometers. 200 kilometers, my lord, Shumoga to Udupi. My lord, she had two minor children, aged about 7 years.
She's working?
No, my lord. Now she
The
taken
doctor.
Respondent is a doctor, my lord. Now, my lord, she is not working, my lord. She taken shelter with the parents' house.
She is a doctor. Go to page 13.
Please, my lord, now not she is working, my lord. Now, my lord.
No, she's a doctor, she is.
My lord, the respondent is a
respondent is a professor.
Doctor, my lord. She is, my lord, working in MIT, Manipal.
You go at annexure A, cost title.
My lord, your lordship kindly, please, my lord. The petitioner is a doctor, my lord. My lord, she had two children, my lord, minor children, my lord, aged about 7 years.
Now he's seeking for restitution.
Please, my lord. Pending on the file of family court at Udupi, my lord. Distance between, my lord, Shumoga to Udupi, my lord, around 200 kilometers, my lord.
In light of the contention that petitioner is required to travel a distance of about 200 kilometers to attend proceedings in MC 10 of 2024. And such travel would inconvenience the petitioner, more so in light of her two children born from within the wedlock, who are aged about
7 years, my lord.
Who are aged about 7 years. Subject to further consideration, there would be stay of proceedings in MC 10 of 2024 till the next date. Emergent notice to the respondent, petitioner is permitted to serve counsel for the respondent who appears before the trial court.
34.
Here for petitioners. This is suit, my lord, for damages and injunction. But it's very sensitive matter, my lord. Both the plaintiff and defendant are MLAs and my lord, they are in the key post of two different political parties, my lord. Now, my lord, the allegation is that the defendant has made certain statement, my lord.
Court notice.
Yes, my lord.
Emergent notice to the, from where to where you want transfer?
Lord, we want, my lord, because of the threat perception, my lord. It has been instituted in Kanakapura. We wanted, my lord, anywhere, my lord, in Karnataka, my lord. Preferably Bangalore may be better, my lord, because It is convenience. Even defendant, my lord, the plaintiff's residence is in Bangalore. But this is a deliberately, my lord, has been filed there, my lord, to harass and humiliate.
It is emergent notice to the respondent. List the matter week after next date code.
27.
27.
The evidence, my lord, is issues are framed, my lord. Therefore, my lord, sought stay of the proceedings, my lord.
No, let us see.
Please.
When you want it, shortest date we'll take it.
Any date, my lord, next week. Or maybe permitted to
Urgent notice to
take
the
out hand
respondent.
summons also.
Petitioner is permitted to take out notice by way of hand summons to the respondent as well as serve counsel appearing for the respondent in the trial proceeding.
Yes, sir.
Release the matter on
21st trial court allo ಇದೆ. Maybe my lord at 20.
Yes.
Great.
Super. 35. Prithvi over here.
Petitioner has appointed the in charge CEO of the fourth respondent society, my lord. In charge CEO of the fourth respondent society, my lord, as per the annexure A, my lord. And later, my lord, he has appointed as a CEO of the fourth respondent society, my lord. And it was sent a report for deputy registrar, my lord. In annexure D, page number 30, my lord. The last fifth line, my lord. Lordship में विषय page 30 my lord, annexure D, my lord.
No, what is wrong with this?
My lord, this order is not challenged, my lord. After concluding this order, my lord, annexure E and F once again issued, my lord, to appointment of CEO of the fourth respondent society. Therefore, the earlier it was appointed as CEO and is approved by the deputy registrar, my lord. Once again, they have issued a notice, my lord, to the society to appoint the.
This post is not filled up, is it?
It is
Now-
filled up, my lord.
Now by next year, my lord, that is a freshly by conducting a recruitment that they want to fill up. But now the petitioner is filed, he is only in charge CEO.
Yeah, after that annexure B, it
He
was.
is not a permanent CEO.
My lord,
Doesn't any right to challenge something which is filled up by a recruitment.
So what is your legal right now?
My lord, it is confirmed and it was discussed and this report was sent to the annexure D, that was annexure D, my lord. Page number 30, my lord, it was your lordship annexure B in the agenda number 4, it was discussed, my lord, by the fourth respondent society. Lordship may, in the last column, my lord, in the agenda number 4, my lord, may ಒಟ್ಟಾರೆ ಅಭಿಪ್ರಾಯ ಪರಿಗಣಿಸಿ
Page
22
30.
22 type copy, my lord.
22.
But you have no vested right. You can take out notice letters.
Please.
Emergent notice. The respondent number 4. AG accepts notice for respondent 1 to 3. You can't have a right. It's up to them if they have to fill up.
Your lordship, my permitted to the respondent number 4, my lord, by oversight, it is secretary, it has been written, my lord. President may be permitted to.
Petitioner is permitted to make an oral request to correct the description of the fourth respondent.
Please.
Mandamus.
No, there are so many other.
Oh,
objections.
typed copies.
You comply. When do you want it?
Because my lords, today itself I will comply.
We'll have it on Friday. Complaint by then.
Because my lords, they are going to issue the final eligible list, my lords, as per annexure H, G, F, G and H, my lords. These are the provisional list, Karadu Prati, my lords. The petitioners, sanghas were the members of the district cooperative, credit cooperative bank, Shivamogga, my lords. These members list is bifurcated and inserted in list number 4, constituency number 4, my lords. H at annexure H and G instead of F, my lords. My grievance is only to include our societies in annexure F, my lords. I have given the representation to that.
You take out notice, you have to comply with office objections.
To
AGA. There is right to accept
R1
notice for the first respondent. Emergent notice to respondent 2 and 3. Petitioners permitted to take out notice by way of hand summons to respondent 2 and 3, which would be in addition to emergent notice through court. Office objections to be complied with forthwith. Please, consideration of interim prayers kept open. List the matter on short date. 21st.
Please. 38, I will comply in office.
Yes, yes.
Nidish BB.
For the petitioner, my lords.
You don't appear for the respondent. You know, kindly pass over. Senior is appearing. He's trying to log in.
38, my lords, your lordships, order of 6/2/24 may kindly be seen. This Honorable Court, my lords, has noticed that the objections against the enforcement of the foreign award stand overruled, recorded the submission of my friend for the respondent that assets will not be, my lords, in any way alienated or encumbered, and directed the affidavit of assets to be filed. Now, the affidavit filed by the respondent discloses, my lords, heavy duty encumbrances on all assets belonging to the respondent. So today about 62 crores, my lords, is owing to the petitioner as a result of the award passed in 2010.
Let us see, we'll pass over. Let us see, let him come.
As your
We'll
lordship.
have it at 2:30. 2:30.
As your lordships, please.
Pass over.
$39. Appear for the
Petitioner. My lord, we have been served with a copy of what the respondents call as a preliminary objection. I would like to file a reply to this. Therefore, my lord, we need some time. We've been served only day for yesterday, and they had full 3 weeks' time to file this piecemeal objection.
Not a piecemeal, words.
Of course, you say so.
Let me, I'm not even.
You're saying so.
That
in your
is-
objection. That's why I'm asking for time to file my reply to what they
Fine,
said.
but I'm just stating that there was an ex parte order passed. In a matter, my lords, where it's especially not maintained, we have taken, therefore, we have taken, my lords, ground of a preliminary objection on the very maintainability, my lords, of the petition. Because it's not even an arbitrable dispute, and all of us are, my lords, before the NCLT. So the matter is pending there. And my lords, here it was moved on a matter which is settled by catering of decisions, that it is not even an arbitrable dispute at all, that we should not hold an EGM. The investors, my lords, they have gotten an order saying we should not now implement. The prayer was that EGM should not be conducted at all. That's not a matter, my lords, for a civil court at all, or for an arbitration.
May I request your lordships to kindly see the.
Let us see. Now they are seeking.
No,
I have something,
on the appearance.
I have something very serious to point out, your lordships.
No, I'm on the appearance, my lords,
Just 1 minute.
Yes, I'm sorry.
Now they're seeking for a short accommodation.
Not
On that date, all of you get ready. We'll
No, I have one
only
serious
on the
objection to make.
housekeeping, my lords, I'll just state.
My lord, I have one serious objection to make. I think, my lord, the respondents who have filed this, what they call as preliminary statement of objections, have really played fraud on this court. And I'm saying so with full sense of responsibility. And if I am right in what I am saying on the basis of what appears in the record of this honorable court, the
respondents, my lord, who have sworn to this affidavit should be proceeded for perjury. Please see why I'm saying it, my lord. Please see why I'm saying it. Please see the date on which the objection is filed. Please look at it, my lord. I'm not saying anything irresponsible in this case. Please be kind enough to turn to page number 26. But this is a serious issue. Just because they're foreign investors, it doesn't mean that, my lord, they can take Indian courts for granted like this. Please be kind enough to turn to page 26. I showed your lordships how the whole thing is manipulated. Please see the date on which it is filed, my lord. It's a serious issue, and I would request your lordship to suo motu initiate action against the deponents. Your lordship got the date, my lord? 11th of March? Your lordship got the date, my lord? Now please see the affidavit, my lord, that is sworn to. And kindly see, my lord, paragraph number 2 of the first affidavit that has been filed by one Mr. Dhawal Batawala, who, my lord, says, who is sitting in Bombay, my lord, represents a company in Singapore, who is respondent number 2 in the proceeding. Kindly see the date on which he swears to the affidavit, 8th of March. And kindly see, my lord, that paragraphs 1 and to 39 is filled up by hand. Obviously, my lord, it's obvious, and there's no explanation given here. Obviously, a statement of objections dated 11th of March 2014, affidavit was sworn to on 8th of March. How is it possible? Lord, the whole thing is taken for so lightly. Lord, I want to file a petition for perjury against the deponent.
Malad, I think. All this anger is all fine.
Not anger.
Now,
it is
Malad, if it is ratified tomorrow, if Malad, it is not. Malad, that is why I thought I'll just, on the housekeeping, I thought I'll say 2, 3, 8, 9, and 12 Malads have filed this objection.
Malad, let them not. That
let,
not issue
let me
be
at least
avoided.
not be interrupted.
Malad,
I'm just stating who I represent.
Malad, I would request your
Malad, let
lordship
me
to
complete saying who I'm representing. Malad, can I at least complete?
I'll grant you.
It's not this serious objection that I have.
No, let Malads 2, 3, I'm not coming in the way, but 2, 3, 8, 9, and 12 Malads have filed this petition on the objection Malads on the very maintainability of it. And Malads 4, 5, 6, 7, 11, and 13 Malads we undertake, we have got instructions. That leaves only 1 and 10 Malads.
One also we have instructions.
And
Once we have instructions.
one also we have got instructions. Malads. That is just to complete the picture. That leaves only 11, only 10 Malads.
One, that is only one.
No, that leaves only 10. That leaves only 10.
I am not on that, my lord. That's okay, my lord.
No.
Record that.
Please record my objections, my lord, on this affidavit.
Then it's submitted that Counsel Lavanya B.
Yes.
Undertakes to appear for respondents 1, 4 to 7, 11 and 13.
Yes.
Registry to take note of the same. Wakalat to be filed by the next date. Then the senior counsel appearing for the petitioners submits that they would file rejoinder.
Yes, no.
To the application.
No, they are not filing any application.
No,
they have only filed what they style as a preliminary statement of objections. They don't even file objections on merits.
Rejoinder to the preliminary objections filed.
Preliminary statement of objections.
Preliminary statement of objections filed by the respondents. Yes. Relist the matter on.
My lord, your lordship may also record, my lord, that.
Let it come by way of an objection. Then your lordship will record.
It is on record. I want it to be.
Then I have something to state on record. That ex parte order was obtained. It doesn't happen.
Correct. When do you want it?
My lord,
can I request for 27th?
My lord, no, 27th. My lord, whatever date suits my learned friend, he comes from outside, my lord, a very dear friend of mine.
I'm making a request for 27th.
I would not, my lord, want to inconvenience him. But this is a serious issue, my lord. I would not.
That doesn't matter, but they have to argue on some day.
I would not have taken up this matter this seriously.
I'm saying I'll argue on that as well on 27th. There's no problem.
No, my lord, please record my submission that there is a. At the outset, I'm pointing out, I'm putting them on notice so that they know, my lord.
My friend has put me on notice.
Let it be recorded, my lord. Why are they fighting shy?
I'm not fighting, my lord. Can I state this, my lord? These are matters, we can keep throwing Mullad's
Why?
as many allegations. I'm saying let it come on paper, let it come paper for petition.
Even
We'll
without-
deal with that.
What more is required? It is on record.
Well, I state that expiry order was obtained by fraud.
That is.
Your Lordship may record that also.
That is a
Doesn't-
matter of merits.
Relist the matter on
27th, Mulad.
No, can be 28th, 27th, I'm going to be out of town. Is it possible?
Congener.
I'm out of town on 26 and 27.
28.
My lord, subject,
Yes.
my lord, of course, my lord. My
28.
learned friend, my lord, comes from outside, so. Whatever suits.
This is the matter on 28th.
My lord, interim order to be extended.
Interim order earlier granted is extended till the next.
My lord, can I ask for this indulgence, my lord?
No, but that
Can this contention be noted?
Mulad's,
put it just one.
I'm sorry.
That you put it in writing, I'll take note of it.
Yes.
sir.
My lord, my subject.
Let
It is on record, my lord.
Let it come in writing. So that even he'll have an opportunity to,
Deep
anyhow you put him on oral notice. he'll
I have put him on oral notice that there is a perjury. And in any event, my lord, so that before then, next time I'll take out an application for perjury.
Not an issue at all.
Yes,
We'll deal.
next.
Oblige.
Great.
Forty,
I'm for petitioner. I'm for petitioner, Your Honor. I filed one memo for withdrawal of petition.
Counsel for the petitioner has filed a memo for withdrawal.
Of CP.
How many pages memo, counsel?
No, that affidavit from the petitioner that she is concerned for the withdrawal of the petition. Because of that, I have filed the affidavit.
Seeking liberty to file afresh in light of the
Because Your Honor, respondent husband not paid maintenance from last 1 year.
in light of the memo filed, petition is dismissed as withdrawn. Liberty as sought for is reserved.
And fix up the date for they filed the MC petition, but for the dissolution of marriage, before
no,
the Bangalore.
So now your petition is withdrawn.
Yes, I am petition.
Ah, so that we have recorded.
Okay, much.
Now whatever is there pending will go ahead.
Okay.
There was any interim order before this court.
Yes, Your Honor, stay of that dissolution of marriage,
Right
type of
of,
petition.
The withdrawal, interim order granted, stands discharged.
41, Sidmal of appeal.
There's some office objection in process memo. I'll rectify the same. And in the meantime, please, my lord, I may be permitted to take notice on the counsel appearing for the respondent in trial court.
The week's time granted to do the needful. Petitioner's liberty to serve counsel for the respondent who appears in the trial proceedings.
Please.
42,
Let the process be in the morning, lord.
Needful is stated to be completed. Office to verify and issue notice to the respondent forthwith. Petitioner is also also to serve counsel appearing for the respondent in the trial proceedings.
43,
Interim order may kindly be extended.
Interim order earlier granted is extended till the next date. Relist the matter on.
27,
Yes.
43,
43, my lord, needful has been done. Once again, steps taken, my lord, today.
The petitioner submits needful is complete.
The interim order may kindly.
The same is in order. Notice to be issued forthwith. Petitioner is at liberty to serve counsel appearing for the respondent in the trial proceedings as well. Interim order earlier granted is extended till the next date. Relist the matter on.
26,
Yes.
44,
Yes. What has happened to the mediation?
Mediation that has been
They
failed.
have
Not ready.
Failed.
Right.
Now you appear for the
I am for-
wife.
Wife, please.
You're seeking transfer from
Somarpete to Anekal.
Somwarpet to
Anekal. Bangalore Road, Anekal.
now you have instituted proceedings under section 9
9, please.
before Anekal.
Please.
Now respondent husband,
The filed 13, sir, cruelty please, for divers.
Where?
Divorce, my lords.
Before?
Somarpet.
before
Somarpet, my lord.
MC number
MC number 90. 90 of 2023, my.
90 of
2023. Senior civil judge and JMFC Somarpet.
what is the distance?
More than 300 hours. 250. sir.
Any children?
Yes, one ವರ್ಷದ ಮಗಿದೆ, ಒಂದೂವರೆ ವರ್ಷ.
The child is with you.
Please.
Both will have to be decided together.
That's filed a statement of objection, my lords. The thing
No,
is,
correct.
my lords.
No, now section 9 and 13 will have to be decided by the same court.
My lords, grievances, my lords, the respondent is a disabled person, my lords. He can't hear, my lords. I have placed the document and record in my statement of objection. It's in page number 4, my lord. ನಾನು ಹೋಗಿ ನಾನು ಇರಕ್ ರೆಡಿ ಇದ್ದೀನಿ ಸರ್. ನಾನು ಡಿಸೇಬಲ್ಡ್ ಪರ್ಸನ್ ಜೊತೆಗೆ ನಾನು ಇದ್ದು ನಾನು ಅವ್ರನ್ನ ನೋಡ್ಕೊಳಕ್ ರೆಡಿ ಇದ್ದೀನಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಲಿವ್ ವಿತ್ ಹಿಮ್. My lords, we have filed under cruelty, my lords.
Yes,
She is
now
trying to.
they have filed a cruelty.
She is trying to kill our respondent, my lords. Therefore, she had deserted to her mother's place.
Now she's ready. This is what she's saying.
No, my lords. They have executed a agreement, please, my lord. They have, but we are not ready, my lords. Therefore, we are sought for divorce under cruelty, my lord. He has filed objections, he has filed a petition. Now their allegation is not able to read and write and walk ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ mediation ಅಲ್ಲಿ appear ಆಗಿದ್ದಾರೆ. They have filed a petition. He has given instructions. Prior to that, himself as his father has. Madam. 30 lakh rupees ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they have not paid. ಈಗ ನಾನು ಕರ್ಕೊಂಡು ಹೋಗಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ, ಅಮೌಂಟ್ ಕೊಡಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ.
So now, if you don't want the relationship, then it must end amicably so that each person can go ahead with their own life. You can't have both, isn't it? Now, if you want to bring an end to the relationship, then you must, now this agreement is executed by you only.
My lords, prior to the filing of the MC petition, my lords, there was agreement. Now they are not ready with that, my lords. Because of this failed ಆಗಿರೋದಕ್ಕೋಸ್ಕರ ಫೈಲ್ ಮಾಡಿದೀನಿ. ಅಮೌಂಟ್ ಆದ್ರೂ ಕೊಡಿಲ್ಲ, ನಾನು ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ ಸರ್.
They're saying that even if this agreement is adhered to, even now they will consider bringing an end to the relationship.
But in a mediation, they have said that they are not ready to accept any.
Now, this is the stand now.
Yes.
We'll have it on Monday. You find out. This is an agreement executed between both of you. Now they're ready, even if you adhere to this. Since you are not ready to take her back, the only way is you have to bring an end to the relationship.
Please, my lords.
Now they're saying you agree to the terms agreed to under the agreement entered into both of you. There ends the matter. We'll have it on Monday, you get instruction.
Please, my lords. Please, my lords.
Relist the matter in the same stage on Monday.
Please, my lords.
Now, either you have to stay together or depart peacefully. If that agreement is entered into, you find out and then make arrangements. We'll give some time and then close it.
Please.
45 attend, 46. Girish. 46, Girish.
Week's time granted to do the needful. Have you served the council?
Yes,
Good.
it has been served on 1/3.
Council for the petitioner files a memo with acknowledgement for having served. Notice of proceedings on the council appearing for the respondent before the family court. Same is taken on record. Fresh steps to be taken for issuance of notice through court. List the matter on 26th. Take out fresh notice also, let it go through court.
Much obliged.
47.
My lords, I appear for the respondent, my lords. I have filed statement of objections, my lords, yesterday. Office may be directed to put up, my lords, on. I've served copy to the other side.
Copy to transfer from where to where?
Mysore to senior civilian at Gubbi,
What is the distance?
distance 170 kilometers.
170?
Kilometers from Gubbi to Mysore.
170.
170. As one child.
Any children?
Yes, child. It's now aged about
My
3
lords,
years.
if I may submit.
And also, she has filed a civil miscellaneous petition for maintenance also. That is pending before the civil
Child,
judge,
child aged about?
3 years. She has born on 13/12/2020. And maintenance case is pending before the Gubbi court. The respondent has appeared and he has filed wakalat also.
He has appeared.
He has appeared.
My lords,
I'll come back to you.
please.
In criminal miscellaneous,
Criminal miscellaneous 217 of 23. 217 of 23. Wife and child as filed, both have filed.
he's paying maintenance.
He's not paying the maintenance.
Not paying.
Not paying.
Is it stayed?
No stay. In semis is concerned, there is no stay. Last occasion they have filed a wakalat. Now the matter is posted for objections to.
No order is passed.
No order is passed, but application is filed for interim maintenance.
Yes, what do you say?
My lords, in 2022, my lords, earlier MC petition was filed, my lords, which is MC number 1150 of 2022.
115 of?
1150 of 2022. 1150 of 2022. My lords, that came to be compromised in Mysuru, and thereafterwards, my lords, a 498A case came to be filed, my lords, against the entire family members. And my lords, after that, post that incident, my lords, after 498A, my lords, I filed MC petition, my lords, for dissolution of marriage in Mysuru. I live with, the husband lives with only his mother, who is also undergone surgery, my lords, heart surgery, and there is no one else in the home.
That is MC number?
MC number, that is 473 of 23, my lords.
Now, what happened to MC 1150 of 20?
1150, my lords, elders, there was a compromise, my lords, and whereby she was directed not to take up any harsh steps, not to commit suicide, not to threaten. That kind of a agreement was there, my lords. And immediately after that, my lords, within 7 days, my lords, she goes from the house and threatening the mother and everybody that she will make sure that the mother as well as the son, only son, they will roam around the courts. So, my lords, thereafter, my lords, MC came to be filed, my lords, MC 473 of 23 before Mysore court, my lords, which is sought to be transferred now before Gubbi court now, my lords. That family court, and there also, my lords, she has filed an application for litigation expenditures and maintenance. That is pending consideration, my lords. The family court is considering those applications. And when those applications were being considered and 498A case charge sheet is filed and that case is running before Mysore court. And now she has filed 125 proceedings before Gubbi court, my lords. All that was not at all required, my lords, because MC court was already considering her application, her own application. And now, my lords, they are quite affluent family, influential, and the respondent is the only earning member, and he has to take care of his ailing mother, who has undergone twice surgery, heart surgery. Now, my lords, these are the peculiar circumstances. The only grievance of the petitioner is that, my lords, 175 kilometers, and she is not traveling any cross state, my lords, and she has got all conveniences to travel. And off late, my lords, even government of Karnataka also has made it very free without ticket for women.
Okay, we have consistently allowing petitions by the wife after following the order in MV Rekha's case.
Also, none.
The
I filed my statement of objections, my lords, records for the sake of records, my lords. I have all, it's there.
Statement.
Listen, court, we have filed yesterday, my lords. It's not put up with the file. Office may be directed to put down with.
No, it's
Copies
there.
of objections, sir.
There.
Huh? It's there.
There.
You consider it.
My lords, no, my only submission is that, my lords, when the MC petition was already filed by me and the larger questions are being considered there, my lords, and 498A is also running before Mysore court where the trials have been already begun, my lords. Charge sheet is filed. She had filed a case against my sister also, and who has been dropped from the charge sheet, my lords, because more than 10 years back, she has already married and settled in Bengaluru, working with her own family. And she's not at all connected, and therefore, my lords, the police have dropped her from charge sheet. Now, the trial is also going ahead in the Mysore. Not that, my lords, she is wanting even 498A matter to be transferred to a Gubbi court. She has to travel to Mysore, my lords. Mysore court is already seized of that divorce proceedings, and when in that divorce proceedings, my lords, she has filed an application for litigation expenditure maintenance. 24 application is pending consideration. And when that court is considering all these things, my lords, abruptly this 125 proceedings is filed with sole object to see to it that this respondent travels, leaving his job, and also to harass the mother-in-law. My lords, ends of justice, my lords, the child is there, my lords. Even I am willing to oblige whatever the trial court is going to consider the facts and circumstances and decides the maintenance, my lords. They are very affluent. We have also placed many documentary proofs on record. My lords, therefore, my submission is that, my lords, if there will be no hardship that would be caused to her, and earlier point of time, my lords, 1150 of 22 was also compromised. And she said she will not do any such thing. She wants to live with the husband. And this is a marriage of very 3.5, 4 years time, my lords. And within that, my lords, the respondent and his mother was harassed, and this all situations came up. So therefore, my humble submission is that, my lords, the petition may kindly be dismissed, and I am willing to, if at all any charges are there, my lords, I'll bear, because I am the only earning member. If I keep traveling, my lords, then again I will not be able to support the child also. I am not one.
We'll direct the court to take recourse through video conference and not insist for personal appearance except when required.
And one more.
Please, lordships, even that is available for madam also, my lords, the petitioner.
They are always.
Because Mysore court is much more equipped with all those facilities is what is my sub.
It is.
Yes.
Yes. The petitioner. Wife has sought for withdrawal of the proceedings instituted by the respondent husband in MC 473 of 2023, seeking dissolution of the matrimonial relationship pending before the family court at Mysore and transfer of the said proceedings to the court at Gubbi.
Senior civil judge.
Gubbi. The petitioner. No children, is it?
One child
One
is there.
child is there.
Aged about
3 years.
The petitioner submits that she is required to travel a distance of about 170 kilometers to attend the proceedings before the family court at Mysore. And considering that she has a child aged about 3 years, the petitioner finds it difficult and inconvenient to travel and attend proceedings at Mysore while leaving behind her the child of tender age. It is submitted that in light of the inconveniences made out, proceedings are to be transferred as sought for. Further, it is submitted that proceedings seeking maintenance have been instituted in criminal miscellaneous 217 of 2023, pending before the court at Gubbi, and said aspect also needs to be taken note of while considering the request for transfer of proceedings, as the respondent has put in appearance before the court at Gubbi in the proceedings seeking maintenance. Next. Learned counsel appearing for the respondent relies on the statement of objections filed and submits that the respondent is currently facing things under 498A of IPC, which matter has reached the stage of trial and is pending before the court at Mysuru. And accordingly, as the petitioner is also required to attend proceedings as a complainant in the proceedings at Mysore, the case made out of inconvenience ought to be rejected. It is further submitted that the respondent is the only adult member of the family and is required to take care of his ailing mother, who cannot be left alone.
She suffered surgery.
It is further submitted that the comparative hardship, if evaluated, the same are the hardship of the respondent also needs to be taken note of while considering the plea made by the petitioner. Next. Heard both sides. Admitted facts are that the petitioner is a resident of Gubbi, and if the petitioner were to attend proceedings before the court at Mysore, petitioner is required to travel a distance of about 170 kilometers. It is not in dispute that the petitioner has a child of tender age, aged about 3 years, and the assertion that the petitioner cannot leave the child alone while traveling to attend proceedings at Mysore requires serious consideration. Full stop. No doubt the respondent husband has asserted that there are inconveniences on his side as well, including that the respondent has an ailing mother with medical ailment who cannot be left alone and needs to be tended to. Next. The respondent no doubt has offered to bear the litigation and maintenance expenses as may be determined by the court.
Family court.
By the family court.
Where she has filed the application.
Which is still pending consideration, and accordingly submits that the question of inconvenience must be looked at from such perspective. However, it is to be noticed that no doubt the respondent may be willing to pay litigation expenses and maintenance as may be decided. But that apart, the inconvenience of the wife in attending proceedings relating to the matrimonial case must be looked at from a different perspective. The psychological impact and stress involved in attending proceedings relating to matrimonial case cannot be discounted. This court in M.V. Rekha's case is observed as follows. In light of the above, the convenience of the wife requires to be taken note of. Where the comparative hardship to both as thought to be made out in the present case. The inconvenience of the wife requires to be given precedence, not only in light of the travel of distance of 170 kilometers, but also as the petitioner has a child of tender age of 3 years. Trial court, however, trial court to which proceedings are transferred, 26th, must however take recourse to video conference facility as is available pursuant to the parties in making use of video conference facilities in light of the rules framed so and so. The court not to insist on appearance of the respondent on all dates except when it is necessary. Accordingly, petition is allowed. Proceedings in MC so and so are withdrawn from the family court at Mysore and directed to be made over to the court at Gupi,
Senior civil judge.
to the designated family court at Gupi. One sentence manner. It is also to be noticed that the respondent is put in appearance in CMS 217 of 2023, filed before the court at Gupi, and accordingly is required to attend such proceedings.
Petition seeking transfer of suit from Dablapura to Bangalore, my lord. Admittedly, my lord, plaintiff is a resident of Bangalore, my lord. I am the defendant number one. Aged about 77 years, suffering from serious diseases, my lord. Here's the document also. Plaintiff is served and underrepresented.
I appear for respondent number 4 to 6, please, my lord. Last occasion I saw
appear
time to
for?
respondent number 4 to 6.
Before the trial court, you are?
I am the defendant number 4 to 6.
So you are defendant number?
One, my lord.
I have no objection for transfer of the suit, please.
That is okay, but you can't, how can we, for all matters, you can't transfer to Bangalore. What is it? There's difficulty everywhere. Video conference you do.
Difficulty
Attend
is this, my
to
lord.
video
The
conference.
only one residential property is located in Dablapura, my lord. Other properties are located in Nelmangla, my lord. And the property is, and the residential property is located in Bangalore. my
It is, you serve the council.
My lord, we have served the council also, and the process was paid, my lord, to this court, by this court. And she served.
Notice.
Notice is served and underrepresented, my lord.
For everything you can't come for transfer. Some.
He is about 77
except-
years, my lord. Having,
That may be so.
even admittedly, my lord, plaintiff is resident of Bangalore, my lord. She's a permanent resident of Bangalore, my lord. Even she's a senior citizen, she need to travel
Petitioner is
from
at
Bangalore to
liberty
Dablapura.
to take out notice by way of hand summons to the respondents, such the trial court to the unserved respondents. Trial court to facilitate such service of hand summons on the next date of hearing before the trial court. When is the date?
Date, no, my lord.
But hand
Trial court.
summons has already been, summons ordered by
Through
this.
court. Now I'm directing through court. Let the.
Through court,
presiding
it has been served through court
No,
only.
let the presiding officer serve.
Please, my lord.
Relist the matter after 2 weeks.
Interim order, my lord.
Interim order is operation.
Operating, my lord. Interim order.
Why interim order in these matters? No, I'm not going to extend interim order. What transfer, you want the civil suit to be transferred and staying the proceedings? Absolutely no, I'm going to vacate the interim order. What is this? What is the distance between Dodbalapura to Bangalore?
My lord,
No, no.
my lord, I'm suffering
Complete
from,
abuse of
I'm
process.
suffering from heart disease, my lord. I'm producing the
that's
document
okay.
as well, my lord.
That's okay. You can't, it's not from
Lord,
Kashmir to Bangalore.
he's unable to travel, my lord. He's a retired person and he's unable to travel to Dablapura. That is the
Not
reason,
from-
my lord.
Everybody in the world have difficulties, council. What is the
Lord,
distance?
my humble
between-
submission is that
No, what is the distance between Dodbalapura to Bangalore?
it's nearly 40 kilometers to 50.
Then, come on, not this. You can't take the court for a ride like this. Interim order earlier granted is extended till the next date code. This is not the extent of abuse of process of court. Not for 40 kilometers.
Lord,
Not for 40
I
kilometers.
apologize, my lord. Only on the ground that he's unable to travel, my lord.
Not for 40 kilometers, council. Don't tell me you're bedridden. No. You can't make use of procedure to stall proceedings. Yes.
I appear for the petitioner, my lords. Process memo was paid. I may be at liberty to serve on the trial court counsel, please.
Weeks time granted to do the needful. Petitioner is permitted to serve counsel appearing for the respondent in the trial proceedings.
There is an interim order in.
Order earlier granted is extended till the next date. Relist the matter on.
28,
Yes.
Grateful.
50,
Appearing petitioner. Needful document.
Petitioner submits
Interim
needful
order
is
may
done.
extend.
Office to verify and issue notice forthwith. Petitioner is at liberty to serve counsel appearing for the respondent in the trial proceedings.
Please.
The
Interim
interim order
order.
earlier granted is extended till the next date. Relist the matter.
28-3.
Yes.
51.
Much.
Weeks time granted to do the needful. Petitioner is at liberty to serve counsel appearing for the respondent in the trial proceedings. Relist the matter on
28.
28.
52.
At request.
Please.
Relist the matter next week.
Next week.
A matter where the matter has been in fact just where they want to urge, that means a few of the legal questions which has to be.
Yes, yes.
Date.
Please. 53.
53, my lord, respond number 5. He was working, he has retired now. He's a
He was a
Inquiry
64
officer.
inquiry officer.
Why the inquiry officer may not be necessary?
Maybe
65 inquiry report is also challenged before this court.
Correct.
then maybe
Let us see.
dispense with.
If if required at that stage, we'll see. We'll
Yes,
just
Please, ma'am.
defer it for the present.
Please.
Notice to the R5 is deferred for the present. Noticing that R5 is the inquiry officer.
Inquiry.
Please.
Now pleadings are complete.
ಇಲ್ಲ ಅವ್ರನ್ನ objection file ಮಾಡಿಲ್ಲ.
File your objection.
Yes.
Objections to be
2 weeks.
filed within 2 weeks.
Interim order may kindly be extended.
Interim order earlier grant is extended till the next date. IA 1 of 22 is allowed and production of certified copy is dispensed with. Subject to the undertaking, same would be produced in due course.
54. Serial number 54, Sarvan is.
Weeks time granted to do the needful.
55. December.
Weeks time granted
Make 10 now, right?
to do the needful. Who's R3?
R3 is a private person.
Necessary. my lord.
Let us see. Yes.
55 and 56,
Interim
they
order.
are necessary. Against them, they are necessary parties.
Let us see.
R3.
Interim order earlier granted is extended to the next date. Same order 55 and 56.
Please.
Some date may be given.
Date good. Date.
57.
Please.
57.
57, I needs to file an objection, my lord. I needs to file objection in 57.
57. Sandesh. Vinod Kumar.
For the respondent of
File objections, they're saying. You have to file.
urgency ಇದೆ ಇದ್ರಲ್ಲಿ election is over, my lord. ಅಲ್ಲ interim order subject to result of the writ petition ಅಂತ ಇದೆ.
Election is over.
ಹೌದು election ಆಗಿದೆ.
quorum conduct the president election, my lord. Respondent number.
I have to file objection, my lord.
File it. We'll
My
fix
lord,
the
2
date.
weeks time. yes.
Also,
Not 2 weeks. Within 10 days, both of you must
Please,
file.
madam, 10.
last date allo ide submission ಮಾಡಿ date.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ
Let us see. Let us see.
ಕಾಪಿನೇ ಸಿಕ್ಕಿಲ್ಲ.
Let us see. Now this matter has to be heard and disposed of. We can't consider only interim prayer. So let the pleadings be complete, we'll have it. The statement of objections by the respondents to be filed within 10 days. Relist the matter on.
26th. 58. 58.
Voting rate. Respondent number 6, the society, I need to file my objections. A week's time may kindly be granted.
This is voting rights, is it?
Please. Voting. Elections are complete.
Correct, we have to announce it now.
There is a stay, there is an order of stay.
Huh?
There is an order of
No,
stay.
that's what we are saying. So
Please.
complete it fast.
Please, ma'am.
Let
So a
either
week's-
way.
No, not more than a week, ma'am.
Relist the matter on
20th.
20th.
Obliged.
59, 60, 61 dismiss. 62. Rashtekar is.
Petitioners has challenged the auction notice, ma'am.
Petitioner?
Has challenged the auction notice in this case, ma'am.
Huh.
Auction is scheduled to be held on 16/3/2018, ma'am.
You come at 2:30.
Yes, ma'am.
72. ಯಾವುದು? serial number.
My lord, may I make a submission? In serial number 69, it is for a settlement of a report. My lord, in this, my client has been trying to get an approval of a loan, has not yet confirmed. I pray for a 10 days time. If it is done, I will settle in 10 days, my lord.
65.
69, my lord.
Let us,
Respondent number 1.
let us see, let us.
That submission has been made from last 9 years.
Not 9 years, my lord. It is for settlement. We are making all our possibility to get a loan. Even the petitioner number 2's husband is a practicing advocate. He came personally to court hall. He went back to bank to get the approval. They said today they have a meeting. If it is done in a 10 days, we will settle, my lord.
For that reason only, my lord, since he's a practicing advocate, I showed the indulgence. From 9 years, my lord, he has been protracting the matter without any positive.
Last chance, you see what can be done.
Please, my lord.
Release the matter in the same stage on 26th.
Please, my lord.
My lord, matter to cell number 70, my lord. I appear for respondent 1.
Yes,
My lord, I require short accommodation to file statement. of-
inform the other side.
I informed, my lord, informed.
At request, list the matter week after next.
Yes, my lord, yes.
Petitioner for the primary society members, your lordship. The respondent number 2 is a union, your lordship, where the petitioner primary societies are the member of the.
Yes.
Petitioners are the directors of the primary societies, your lordship. And the primary societies, your lordship, of the petitioners are the members of the Mandya, which is an apex society, your lordship, apex body. Your lordship, one Mr. Ravi, who is one of the director, your lordship, he has
The
been.
respondent is the Apex Society.
Respondent number 2, your lordship.
Yes.
Your lordship, here, one Mr. Ravi, your lordship, has been terminated due to lack of delegation as the, who has been delegated for the respondent union, your lordship. He has been terminated as there is for want of administrator has been appointed in the primary society, your lordship. Thereafter, your lordship, to fill up the vacancy, your lordship, as per section 29E, your lordship, for a moment, I may be permitted to take section 29E of the cooperative society, your lordship. There should be a fill up of vacancy, your lordship, the term, if within half of the term is left, means it is by election. Above half of the term means it has to be done through the co-option, your lordship, of the same class persons who has been member. Here, the person, your lordship, has been appointed as a director, co-opted, respondent number 4 has been co-opted, your lordship. Neither his name has been mentioned in the eligible list, neither the board is in the existence, your lordship. That order has been challenged before this honorable court, your lordship. Your lordship, for a moment, your lordship, serial number 21, your lordship, this is the eligible list prepared by the respondent number 2 themselves, your lordship.
When is the election? Is there any election to the Apex Society?
Co-option has been done, your lordship.
No. So now, what is the urgency now?
Your lordship, I being eligible, the primary is a same class person means other primary society directors, your lordship. Section 29E specifically says, your lordship, co-option should be done in the same class person who has been directors of the primary society, your lordship, not otherwise. Here illegally, someone who is, the board is not at all existence, he is not a director, neither a director, his name is not found in the eligible list. Nothing has been done. All of a sudden, majority of some of the member have said he is ineligible, he cannot be co-opted. But here they have been co-opted, your lordship. And in glow with each other. 29E, your lordship, for a moment, your lordship.
No, now you take out notice? We'll have it next week. We'll, in their presence, we'll hear and dispose of.
Your lordship, it has to be stated because the person, for a moment, your lordship, provided further that the board may fill up a casual vacancy of the board by nomination out of the same class of members. Specifically says same class of members. Here, your lordship, the third respondent who is claimed to be fourth respondent, who is claimed to be a member of the third respondent primary society, your lordship, their eligible list I may be permitted. Serial number 21 of the.
Just 1 minute. Nomination is done by the government, is it?
No, my lord.
No. It is only by the respondent number 2 board, your lordship.
Apex Union, my lord.
It is a government assistance.
We'll have it tomorrow, you serve them. We'll hear them and we'll see what interim orders to be passed.
Your lordship, please, your lordship.
Lord, one more request. This is the board proceedings, my lord. He has a remedy under section 70, not before this court, my lord. It's a board resolution. If everyone comes before this court without availing the remedy available under section 70,
You can raise a dispute. Why are you coming directly?
Your lordship, raise a dispute between the body existence, your lordship. Here, the board is not at all existence, and there is no remedy available under section 70, your lordship. That's the reason I have approached this honorable court. Because here the member who is a director, then it has to be go before the section 70. Here he is nowhere a member, neither is the primary society, board is existence. The question of dispute do not arise, your lordship.
There's an administrator.
Please, your lordship, administrator has been appointed in that.
No, administrator is appointed by the government.
Lord,
Please, please, your
even
lord.
assume a moment, my lord, the administrator is appointed to the milk union, Monday Milk Union,
Not
He
milk
will-
union, primary society,
primary society.
proper society.
It may be, my lord, that doesn't that
No, what
doesn't
I'm-
makes any
No,
difference, my
correct. So
lord.
what I'm saying,
May I
you can
request?
get instructions from the administrator.
My lord,
We'll have it day after tomorrow.
I agree, but he had challenged the decision of the second respondent society, that is a milk union, Monday Milk Union.
I'll may be permitted to serve them also, your lordship. milk
primary
union and
member.
the administrator. Your lordship, this is the vote eligible list,
Now-
your lordship, in page number 20.
Now the petitioner being a member of the third respondent society, he says that I am an eligible person, I should be a delegate to the second respondent society. His contention is that he questioned the proceedings of the second respondent society. There is a meeting proceedings that the remedy is available under section 70 proceedings, my lord.
Co-option has been challenged, your lordship.
Let us see, let us see. Please. AG is directed to accept notice for
One.
first respondent. Emergent notice to the respondent 2 and 3. Petitioners permitted to take out notice by way of hand summons as well. For respondent 2 and 3, emergent notice to the fourth respondent. The petitioner is permitted to carry out the error in description of the second respondent. Spelling mistake. List the matter on. We'll have it on Friday.
Please, your lordship.
We'll list the matter
Your
on
lordship,
Friday.
Thursday, Friday, please. Your lordship.
Consideration of interim prayers kept open.
Much. Lordship, sir. Your lordship, a short pass over, your lordship.
We'll have it tomorrow.
Your lordship, tomorrow is the co-option date here, your lordship. They're going to nominate a co-option.
Today, there's no time. Everybody's waiting. Let us pass
Your
over.
lordship, I may be permitted to address my argument.
Huh?
I'll argue the matter.
No, I'll pass over. Let us. Before rising, I'll take it up.
Much. Please.
Yes, next.
Appear for petitioner minutes. Kindly permit me to produce this stay.
Just a minute, I'm not ready. Application seeking stay is taken on record.
Obliged.
Yes. Same order.
For the petitioner, my lord. My lord, by order dated 6/2/2024, this honorable court was pleased to direct
For the
the
respondent.
respondent to file their affidavit of assets, my lord. They've since filed their affidavit of assets. A perusal of the affidavit of assets shows there's nothing that is unencumbered. And the award amount as on date is about 62 crores, my lord. And given this 100-page affidavit of assets that they have filed, there is hardly anything that they can show that is unencumbered. They may be directed to deposit the amounts before this honorable court, my lord.
Lord, I appear for the respondent company.
Yes.
Yeah. My Lord, first my apologies, I was not in court in the morning. My Lord, against the judgment of your Lordship's court, rejecting our objections, an SLP has been filed. The SLP came up on the 5th of this month. It's on Friday, my Lord, day after tomorrow. Item 27. So all I'm asking for is a short adjournment because the Supreme Court may either reject my SLP, grant me a SLP, unconditional leave, conditional leave, whatever. My Lord, day after tomorrow, Friday.
We'll have it on Tuesday. It is
At their request, ma'am.
at request made on behalf of the respondent that matter filed by the respondent is listed before the apex court on Friday. List the matter in the same stage on Tuesday.
Could it be on Wednesday, my lord, if it's convenient? to the Chief
Wednesday,
Counsel?
Wednesday.
Deeply
Yes,
obliged.
ma'am. I'm obliged to my lord.
Yes.
And I'm sorry I was not on the air, not in the morning.
That's all.
Waiting for a office objection is that my lord, annexure E is not legible. We are written as no office note regarding that, my lord. It is
The office objection is kept in abeyance, subject to the undertaking that if the said document is relied on by the petitioner at the time of hearing of the matter, legible copy will be furnished. Yes.
has challenged the auction notice, my lord. Petitioner has challenged on the ground that the respondent bank has not complied with the Rule 38 subclause 2 of the Cooperative Societies Act, my lord. The auction should be held at the place where the property is situated, but they are holding at the respondent bank, my lord.
When is the auction?
Auction is scheduled on 16th, my lord.
On?
16th, my lord.
We'll have it tomorrow.
Kindly subject to deposit.
Let us see tomorrow.
Madam,
It's the matter.
kindly pass on, my lord, the seniors.
Tomorrow we'll have it.
Personal inconvenience for senior, my lord, tomorrow.
No, 16th.
Yes, madam.
No, I'm saying the auction is on 16th.
Yes, madam.
You're seeking for interim prayer, isn't it?
Yes, madam.
So I'll consider it tomorrow. You come tomorrow. List the matter in the fresh matters list tomorrow. Let me also have a look at the file.
Yes, grateful.
Pass over, minutes. Pass over.
There's one election matter I'll start, and after that we'll take it up. What is this memo for withdrawal?
One of the petitioner counsel has filed memo for withdrawal.
In both them, only one of them.
One of them.
Who has filed memo?
Frivolous petition it is. Some Saket Bishani has filed that. Frivolous petition has been filed, matter has gone up to the Supreme Court 3 times, everything has been settled, your lordship. It is the amount, compensation amount to be deposited, your lordship.
No, I'll take it up, we'll hear it. Pass over. Other matters, I'm not sure if it's going to reach. Those who are the emergent matters, I'll take it up. So if there is some emergency relief that you have sought, I will take it up before I rise. Others who don't mind taking matter being taken up on some other day, you make a request to the court officer, dates will be fixed.
67.
67.
74.
Just 1 minute.
May I make one submission?
Just 1 minute.
In the election petition,
Just
I will start straight away.
Yes.
I may need short accommodation when the first court matter reaches. So say up to 4 o'clock, I'll carry on.
Yes.
Afterwards,
Yes.
please.
67.
Yeah, but it's falling fine.
I may be permitted for a date. Pray for a.
67. This is that apartment owners.
Yes, madam.
Yes.
That's 74 and 67.
67 and
74. I don't want an adjournment, my lord. Just 2 minutes hearing after that. Last the chance.
I can't. No, just 1 minute. This is a matter that requires some decision because it has implication on other matters.
I understand, but only the issue, my lord. There is an interim order of this court which told that matter should not be precipitated for
No,
me
that-
to
let us-
consider. So I need the same thing applicable to the petitioner also, my lord, for that he shall not hand over the apartment association maintenance activity to an association which is unregistered and it represents.
us see.
Let them not precipitate now till the hearing.
Let
Let
us
them
see.
not do that activity, only that.
No, I'll fix a date. And now
Before
this-
21st, that should be,
Yes,
because they are doing that activity on.
And there are other matters also.
Yeah.
I intend to appoint an amicus
Yes,
insofar as the legal positions.
very well.
67 and 74, we can have it together.
Yes.
Only insofar as legal contentions that may overlap. But we will, when we are deciding it on merits, we will delink and decide separately.
Lord, 67, there is an interim order.
That will
May
extend.
please be
Yes.
extended.
So, my lord,
My lord,
67 and 74.
74,
We'll have it on the same day.
my lord. But it should be before 21st, my lord, because there is a.
No,
other-
we'll fix a date.
Yes.
67 and 74. Relist the matter on
18th,
20th.
on 20th is 19th, my lord, 19th or 18th.
On 19th.
Oblige.
In light of the legal issues raised, Learned Counsel Shri G. Sridhar is appointed as an amicus to assist the court parties to serve copies on the amicus. The registry to show the name of amicus in the list in order so that amicus may be notified.
Serial number 63, my lords, from yesterday to today.
Extended till
my
the interim order
may please
operation is extended till the next day.
Item number 71, my lord.
In both 74 also. Interim order.
Let us see,
74.
now you can just wait, take a chance, wait. Those who have some urgency, you want to wait,
24 also interim.
you take a chance, the dates you can take from the court officer.
64, serial number 64.
So that you ask, the court officer will give the dates.
Interim order is.
Yes, wherever interim orders are there, matters are not taken up,
My lord,
it will,
My lord.
interim orders will stand extended.
item number 71, we are on agreement to refer the matter to mediation, my lord. It is
70?
71, only 1 and 2, that is matrimonial matter.
Matter, in light of the submission made by both sides, matters referred for mediation. The center or anybody, any advocate,
Any advocate? Prashant Chandra is.
learned
Prashant Chandra
counsel,
or Sushila. Senior counsel.
Shri S.N. Prashant Chandra is appointed as a mediator.
Next TP, next TP.
Explore possibility of amicable resolution.
71.1, the interim order may be.
Interim order in force is extended till the next date.
Right.
This is the.
I was arguing on the application under Order 7, Rule 11 for dismissal of the election petition. Summary-
Yes, Mr. Ravi Kumar told me that he will give the list of synopsis and also the authorities before today. I have not yet received any copy.
Yes, I had assured my learned friend. It is ready, but
Give
it is.
Convenient way I can argue. Give it
No,
to me.
no. Please listen to me. Instead of becoming a synopsis, it has become a voluminous. I have the written submissions ready, but I thought I'll condense it and make it a bullet point presentation. I'll definitely give it to my learned friend.
So that when I convenient, we can avoid the time. Save the time, let him give it.
Yes, let them continue and then we will
Yes,
accommodate.
Objection.
Yes.
Please.
Only one thing I wanted to submit, my lord. The matter is listed before Supreme Court today at serial number 101. Arguments are being taken up. The Supreme Court wants to pass the judgment on Balaji's case before Sunday.
Let us see, let us. Yes. Yes.
Please. Order 7, Rule 11. I'm complaining that the election petition does not disclose any cause of action in respect of the 11 prayers they have made.
So can we ask the others to come after about half an hour?
Yes. That meant.
Others need not wait, they can come after about half an hour. Yes.
So I was submitting with reference to Kanimoli's case, the latest legal position and the declaration of law by the Honorable Supreme Court on this all-important question of dismissal of an election petition on the ground it does not disclose the cause of action. Sir, I was reading at para 57, that is para 26, in which Anil Vasudev Salgaokar's case judgment is extracted. The case law is reviewed. Kindly come to the internal page, page 15, internal page 15 may kindly be perused. Pramila ಅವರ ಕನ್ನಿಮೋಳಿ ಕೇಸ್ ಓದ್ತಾ ಇದ್ದೀನಿ.
Followed that. That was only in respect of Form 26. No other offense was there. Kanimoli's case. My lordship, your lordship is aware, your lordship has rendered judgment in Gauri Shankar's case. Only that was the contention in Kanimoli's case. No other practice was alleged, and they had not disposed. The 5 year bank accounts were not disposed. Hence, the court said it is not liable. Cause of action is not there. No other governments are there in Kanimoli's case.
Let us see.
Please. Page 15, I was reading the extract of Harkirat Singh versus Amrinder Singh, paras 51, 52, 53, 57 I have read, 58 kindly permit me to read. There is no definition of material facts, either in the Representation of People Act, nor in the Code of Civil Procedure. In a series of judgments, this court has laid down that all facts necessary to formulate a complete cause of action should be termed as material facts. All basic and primary facts which must be proved by a party to establish the existence of a cause of action or defense are material facts. Material facts, in other words, mean the entire bundle of facts which would constitute a complete cause of action. This court in Harkirat Singh versus tried to give a various meaning to material facts. The relevant para 48 of the judgment is reproduced. Quote, the expression material facts has neither been defined in the Act nor in the Code. According to the dictionary meaning, material means fundamental, vital, basic, cardinal, central, crucial, decisive, essential, pivotal, indispensable, elementary, or primary. Burton's legal thesaurus. The phrase material facts, therefore, may be said to be those facts upon which a party relies for its claim or defense. In other words, material facts are facts upon which the plaintiff's cause of action or the defendant's defense depends. What particulars could be said to be material facts would depend upon the facts of each case, and no rule of universal application can be laid down. It is, however, absolutely essential that all basic and primary facts which must be proved at the trial by the party to establish the existence of a cause of action or defense are material fact and must be stated in the pleading by the party. Unquote. In Ramsuk versus Dinesh Agarwal, this court again, while examining the maintainability of an election petition, filed under section 101D4 of the RPI, elaborately considered the earlier decisions and observed that it was necessary for the election petitioner to aver and observed that it was necessary for the election petitioner to aver specifically in what manner the result of the election in so far as it concerned the returned candidate was materially affected due to omission on the part of the returning officer. The court in the said case, having found that such averments being missing in the election petition, upheld the judgment of the High Court Election Tribunal, rejecting the election petition at the threshold. The court observed, quote, the requirement in election petition as to the statement of material facts and the consequences of lack of such disclosure with reference to sections 81, 83, and 86 of the Act came up for consideration before a three-judge bench of this court in Samant Balkrishna versus Judge Fernandez. Speaking for the three-judge bench, M. Hidayatullah CJ inter alia laid down that 1. Section 83 of the Act is mandatory and requires first a concise statement of material facts and then the fullest possible particulars. 2. Omission of even a single material fact leads to an incomplete cause of action and statement of claim becomes bad. 3. The function of particulars is to present in full picture of the cause of action and to make the opposite party understand the case he will have to meet. Kindly mark it, this is crucial. It is to make the opposite party understand the case he will have to meet. In the instant case, we'll put this test, put this election petition to this test, whether it discloses any fact at all where I am required to meet at least one material fact in respect of 11 prayers that are made. I'll just demonstrate. So this is the crucial declaration of law. I repeat, it is to make the opposite party understand the case he will have to meet. Material facts and particulars are distinct matters. Material facts will mention statements of fact and particulars will set out the names of persons with date, time, and place. In stating the material facts, it will not do merely to quote the words of the section because then the efficacy of the material facts will be lost. At this juncture, in order to appreciate the real object and purport of phrase material facts, particularly with reference to the election law, it would be appropriate to notice the distinction between the phrases material facts as appearing in clause A and particulars as appearing in clause B of subsection 1 of section 83. As stated above, material facts are primary or basic facts which have to be pleaded by the petitioner to prove his cause of action and by the defendant to prove his defense. Particulars, on the other hand, are details in support of the material facts pleaded by the parties. They amplify, refine, and embellish material facts by giving distinctive touch to the basic contours of a picture already drawn so as to make it full, more clear, and more informative. Unlike material facts, which provide the basic foundation on which the entire edifice of the election petition is built, particulars are to be stated to ensure that the opposite party is not taken by surprise. The distinction between material facts and particulars and their frequent, this may be skipped, please. Kindly come to straight away para 18. Undoubtedly, by virtue of section 87 of the Act, the provisions of the code apply to the trial of an election petition. And therefore, in the absence of anything to the contrary in the Act, the court trying an election petition can act in exercise of its power under the code, including Order 6, Rule 16, and Order 7, Rule 11 of the Code. The object of both the provisions is to ensure that meaningless litigation, which is otherwise bound to prove abortive, should not be permitted to occupy the judicial time of the courts. If that is so, in matters pertaining to ordinary civil litigation, it must apply with greater vigor. In an election matter, where the pendency of an election petition is likely to inhibit the elected representative of the people in the discharge of his public duties, for which the electorate have reposed confidence in him, the submission therefore must fall. Coming to the second limb of the argument, namely, absence of Section 83 in Section 86 of the Act, which specifically provides for dismissal of an election petition, which does not comply with the certain provisions of the Act. In our view, the issue is no longer res integra. A similar plea was negatived by a 3-judge bench of this court in Hardwari Lal versus Kanwar Singh, wherein, speaking for the bench, A.N. Ray, judge, as his lordship then was, said, quote, counsel on behalf of the respondent submitted that an election petition could not be dismissed by reason want of material facts because Section 86 of the Act conferred power on the High Court to dismiss the election petition, which did not comply with the provisions of 81, Section 82, and or Section 117 of the Act. It was emphasized that Section 83 did not find a place in Section 86. Under Section 87 of the Act, every election petition shall be tried by the High Court, as nearly as may be in accordance with the procedure applicable under the Civil Procedure Code, to the trial of the suits. A suit which does not furnish a cause of action can be dismissed. The issue was again dealt with by this court in Askar Hussain versus Rajiv Gandhi, referring to the earlier pronouncements in Samant Balkrishna and Udav Singh, wherein it was observed that the omission of a single material fact would lead to the incomplete cause of action, and that an election petition without the material facts is not an election petition at all. The bench in Askar Hussain said that all the facts which are essential to clothe the petition with the complete cause of action must be pleaded, and omission of even a single material fact would amount to disobedience of the mandate of Section 83 1A of the Act. An election petition can be and must be dismissed if it suffers from any such vice. We may now advert to the facts on hand, examine, etc., that they go to the facts of the case and find that no cause of action is discussed. Para 28 is the summary. Kindly permit me to read. Bottom of the page. The legal position enunciated in aforestated cases may be summed up as under. 1. Section 83 1A of the Representation of People Act mandates that an election petition shall contain a concise statement of material facts on which the petitioner relies. The material facts are not stated in an election petition. The same is liable to be dismissed on that ground alone, as the case would be covered by Clause A of Rule 11 of Section 11, Order 11 of the Code. 2. The material facts must be such facts as would afford a basis for the allegations made in the petition and would constitute the cause of action. That is, every fact which it would be necessary for the plaintiff petitioner to prove, if traversed, in order to support his right to the judgment of the court. Omission of a single material fact would lead to incomplete cause of action, and the statement of plaint would become bad. 3. Material facts mean the entire bundle of facts, which would constitute a complete cause of action. Material facts would include positive statement of facts, as also positive averment of a negative fact, if necessary. 4. In order to get an election declared as void under Section 101D4 of the Representative People Act, election petitioner must have on account of the non-compliance with the provisions of the Constitution or the Act or any rules or orders made under the Act, the result of the election, insofar as it concerned the returned candidate, was materially affected. 5. Election petition is a serious matter and it cannot be treated lightly or in fanciful manner. Kindly mark it, sir. This is very important. On all fours, this will apply to our case. I repeat, the election petition is a serious matter and it cannot be treated lightly or in a fanciful manner, nor is it given to a person who uses it as a handle for vexatious purpose. 6. An election petition can be summarily dismissed on the omission of a single material fact leading to an incomplete cause of action or omission to contain a concise statement of material facts on which the petitioner relies for establishing a cause of action in exercise of the powers under Clause A of Rule 11 of the Order 7 of Code of Civil Procedure, read with the mandatory requirements enjoined by Section 83 of the Act. Then conclusion is reached based on the facts of that case. So this is how it is. One more paragraph, if I may trouble. Kindly come to para 31 in the next page. Mere bald and vague allegation without any basis would not be sufficient compliance of the requirements of stating material facts in the election petition. As well settled, not only positive statement of facts, even a positive statement of negative fact is also required to be stated, stated, as it would be a material fact constituting the cause of action. The material facts which are primary and basic facts have to be pleaded by the election respondent in support of the case set up by him to show his cause of action, and omission of a single material fact would lead to an incomplete cause of action, entitling the returned candidate to pray for dismissal of the election petition under Article 7, Rule 11A of the Code of Civil Procedure, read with Section 83, 1A of the Act. 33 also may kindly be perused. As elaborately discussed earlier, Section 83, 1A of the Representation of People Act mandates that an election petition shall contain a concise statement of material facts on which petitioner relies, and which facts constitute a cause of action. Such facts would include positive statement of facts as also positive averment of negative fact. Omission of a singular fact would lead to incomplete cause of action. So far as the present petition is concerned, there is no averment made as to how there was non-compliance with the provisions of the Constitution or the Representation of People Act or the rules or the order made under the thereunder, and as to how such a non-compliance had materially affected the result of the election petition, so as to attract the ground under Section 101D4 of the Representation of People Act for declaring the election to be void. The omission to state such vital and basic facts has rendered the petition liable to be dismissed under Article 7, Rule 11A of the Code of Civil Procedure, read with Section 83, 1A of the Representation of People Act 1951. So this is the law as it stands today, has been laid down after an exhaustive review of the entire case too. Then on the same proposition, Article 7, Rule 11. This has also been cited in Kanimoli's case. The Art Fernandez case is very important. In fact, it laid the foundation for the development of this law on material facts. Samant Balkrishnan versus George Fernandez. Madam, 1969-3. Wow, you are an expert in George Fernandez case. It's alive. The law is so well settled. Just kindly permit me to read two paragraphs. Para 29 at page 250. They say you will not be allowed to lead evidence of the degree. Para 29 at page 250. Now this is the case where one of the Congress giants, S.K. Patil, was defeated by the trade union leader, George Fernandez. And S.K. Patil himself did not file an election petition, but he had set up another voter to file the election petition. And as a party to the election petition, he strongly supported. In fact, he also filed an appeal to the Honorable Supreme Court. So Supreme Court had occasion to deal with it. Kindly come to para 29. After extracting the provisions of the law, this is what they say. Having dealt with the substantive law on the subject of election petitions, we may now turn to the procedural provisions in the Representation of People Act. Here, we have to consider sections 81, 83, and 84 of the Act. The first provides the procedure for presentation of the election petitions. The proviso to subsection alone is material here. It provides that an election petition may be presented on one or more of the grounds specified in subsection 1 of section 100 and 101. That, as we have shown above in subsection 1 of section 100, as above shown, creates the substantive right. Section 83 then provides that the election petition must contain a concise statement of material facts on which the petitioner relies, and further state he must also set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of the commission of each such practice. Kindly mark it. The date and place. Not a single date is mentioned. Not a single person's name is given. Much less is any place mentioned. The section is mandatory and requires first a concise statement of material facts, then requires the fullest possible particulars. What is the difference between material facts and particulars? The word material shows that the facts necessary to formulate a complete cause of action must be stated. Omission of a single material fact leads to an incomplete cause of action, and the statement of claim becomes bad. The function of particulars is to present as full a picture of the cause of action, such further information in detail as to make the opposite party understand the case he will have to meet. There may be some overlapping between the material facts and particulars, but the two are quite distinct. Thus, material facts will mention that a statement of fact, which must be set out, was made, and it must be alleged that it refers to the character and conduct of the candidate, that it is false, or which the returned candidate believes to be true, believes to be false, or does not believe to be true, and that it is calculated to prejudice the chances of the petitioner. In the particulars, the name of the person making the statement with the date, the time, the place will be mentioned. Material facts thus will show the ground of corrupt practice and the complete cause of action, and particulars will give the necessary information to present a full picture of the cause of action. In stating the material facts, it will not be merely to quote the words of the section, because then the efficiency of the words material facts will be lost. The fact which constitutes the corrupt practice must be stated, and the fact must be correlated to one of the heads of the corrupt practice. Just as a plaint, without disclosing a proper cause of action, cannot be said to be a good plaint, so also an election petition without the material facts relating to a corrupt practice is no election petition at all. A petition which merely cites the sections cannot be said to disclose a cause of action. Where the allegation is the making of a false statement, that statement must appear, and the particulars must be full as to the person making the statement, the necessary information, Formerly, the petition used to be in two parts. The material facts had to be included in the petition and the particulars in a schedule. It is inconceivable that a petition could be filed without the material facts and the schedule by merely citing the corrupt practice from the statute. Indeed, the penalty of dismissal summarily was enjoined for petitions which did not comply with the requirement. Today, the particulars need not be separately included in a schedule, but the distinction remains. The entire and complete cause of action must be in the petition in the shape of material facts, the particulars being the further information to complete the picture. This distinction is brought out by provisions of section 86, although penalty of dismissal is taken away. Subsection 5 of that section provides, quote, the High Court may, upon such terms as to cause and otherwise as it may deem fit, allow the particulars of any corrupt practice alleged in the petition to be amended or amplified in such manner as may, in its opinion, be necessary for ensuring a fair and effective trial of the petition, but shall not allow any amendment of the petition which will have the effect of introducing particulars of a corrupt practice. Kindly mark it. It will have the effect of introducing particulars of a corrupt practice not previously alleged in the petition. Unquote. The power of amendment is given in respect of particulars, but there is a prohibition against amendment which will have the effect of introducing particulars of a corrupt practice not previously alleged in the petition. One alleges the corrupt practice in the material facts, and they must show a complete cause of action. If a petitioner has omitted to allege a corrupt practice, he cannot be permitted to give particulars of the corrupt practice. The argument that the latter part of the fifth subsection is directory only cannot stand in view of the contract in the language of the two parts. The first part is enabling, and the second part creates a positive bar. Therefore, if a corrupt practice is not alleged, the particulars cannot be supplied. There is, however, a difference of approach between the several corrupt practices. If, for example, the charge is bribery of voters and the particulars give a few instances, other instances can be added. If the charge is use of vehicles for free carriage of voters, the particulars of the cars employed may be amplified. But if the charge is that an agent did something, it cannot be amplified by giving particulars of acts on the part of the candidate or vice versa. In the scheme of election law, there are separate corrupt practices which cannot be said to grow out of the material facts related to another person. Publication of false statements by an agent is one cause of action. publication of false statements by the candidate is quite a different cause of action. Such a cause of action must be alleged in the material facts before particulars may be given. One cannot, under the cover of particulars of one corrupt practice, give particulars of a new corrupt practice. They constitute different causes of action. Since a single corrupt practice committed by the candidate, by his election agent or by another person, though there are facts that may be skipped. Just one concluding paragraph, para 60 may kindly be seen. And the election petitioner was represented by one of the mightiest council in the country. Kindly come to para 60. At page 267. To conclude and summarize our findings, we are satisfied that Mr. Atre, as the editor of Maratha, published false statements relating to the character and conduct of Mr. Patil, calculated to harm the prospects of Mr. Patil's election. That Mr. Atre was the agent of Mr. Fernandez under the election law. But there is nothing to prove that he did so with the consent of Mr. Fernandez, nor can such consent be implied, because in making the statements, Mr. Atre was acting as the editor of his own newspaper, the Maratha, and not acting for Mr. Fernandez. We are further satisfied that the petitioner has failed to establish in the manner laid down in this court that the result of the election was materially affected insofar as Mr. Fernandez was concerned. We are also satisfied that if the petitioner had pleaded the corrupt practice against Mr. Fernandez personally, which he did not, the result might have been different. The election petition was ill-considered and left out the most vital charges, but for that, the petitioner must thank himself. So the election petition was dismissed. So this is so I'm citing this to just to state, mere quoting the provision of law will not bring home the material facts of a corrupt practice. Now, of the 11 charges leveled against me and prayers made for setting aside my election, one of the crucial prayers made, it relates to election expenses. Now, that's a very serious charge. Now, in order to demonstrate what are the ingredients of a corrupt practice under section 123, clause 6, for which there is a prayer made in the election petition, may I request the court to kindly turn to the Representation of People Act 123. So this is, I am giving only as a test case. We need not test the entire bowl of rice. One grain is enough to show whether it is baked or not baked. I'll show through this what is the corrupt practice under 123(6). Now 123(6) says, it is a corrupt practice, the incurring or authorizing of expenditure in contravention of section 77. So either I am myself incurring the expenditure, or I am authorizing incurring of expenditure. What is that expenditure which I am supposed to incur? And what is it that it is beyond the permitted expenditure? Incurring or authorizing of expenditure in contravention of section 77. Now kindly come to section 77 for a minute. The heading is account of election expenses and maximum thereof. Every candidate at an election shall, either by himself or by his election agent, keep a separate and correct account of all expenditure in connection with the election incurred or authorized by him or by his election agent between the date on which he has been nominated and the date of declaration of the result thereof, both dates inclusive. This is about the maintenance of the class 3 may kindly be perused. This is the crucial provision. The total of the said expenditure shall not exceed such amount as may be prescribed. So 77 imposes a limit on the election expenses. I am not supposed to incur expenditure beyond the permitted. Now, what is that permitted this thing? That is to be prescribed. Now, kindly come to the rules. Rule 90 may kindly be perused. Conduct of election rules, Rule 90. The total of expenditure of which account is to be kept under section 77,
Sorry.
and which is
Mr. Ravi, which rule you mentioned? Conduct of election rules? Which rule?
rule 90.
Nine.
ತಮ್ಮ ಪೆಟಿಷನ್ ಹೇಳಿದಿರಿ ಹೌದು
ನೀವು
ಕರಪ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಂತ ಹೇಳಿದಿರಿ
I heard at 19. That's why I asked you that.
ಸಾರಿ 90
Okay.
90.
But I asked you. Okay.
77 says the maximum is prescribed. What is the maximum prescribed? Rule 90 prescribes it. The total of the expenditure of which account is to be kept under section 77 and which is incurred or authorized in connection with an election in a state or union territory mentioned in column 1 of the table below shall not exceed. A is for the parliament, leave it. In any one of the B is important. In any one assembly constituency, if any, of the state or union territory, the amount specified in the corresponding column 3 of this head table. Kindly come to serial number 11 in the table. Serial number 11, Karnataka, 10. Karnataka is 10. I think
What is that?
it has now been added, another state has been added with effect from 6/1/2022. So it is substituted. The table is substituted on 6/1/2022. Karnataka comes at serial number 11.
What is that?
This is the one which governs. May I just pass on. Pass on. ಮೊದಲೆಲ್ಲ ಜಡ್ಜಸ್ ಲೈಬ್ರರಿಲಿ
We are always one step.
216.
ಗೆಜೆಟ್ ಬಂದ್ ಕೂಡಲೇ ಅದನ್ನ ಕಟ್ ಮಾಡಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ರು. ದೇ ಇಸ್ ಟು ಮೇಕ್ ಎ ಕರೆಕ್ಷನ್. ರೆಡ್ಡಿ ಅಂತ ಇದ್ರು ಲೈಬ್ರರಿಯನ್ ಈಸ್ ಟು ಡೂ ದಟ್.
ಇದೆ ಪೇಜ್ ಲೇಟೆಸ್ಟ್ ಎಡಿಷನ್ ಅಲ್ಲಿ ಪೇಜ್ 216. Conductor's rule are there in the page 216, 40 lakhs.
Correct. 216.
Yes.
Yeah. Serial number 11.
Yes.
ಕರ್ನಾಟಕ ಪಾರ್ಲಿಮೆಂಟ್ಗೆ 95 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಬಹುದು.
ಅಸೆಂಬ್ಲಿಗೆ
40 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಬೇಕು.
Correct.
So the case of the petitioner is has spent more than 40 lakhs. It is not stated in so many words, but I am assuming that that could be the charge. Because I would also request the court to kindly see if there is an allegation of corrupt practice. Two things are required. What are they? Kindly come to section 83. For a minute, section 83.
Page 87. Page 87 there.
An election petition shall contain a concise statement of material facts on which the petitioner relies. B is important. Shall set forth particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of the commission of each of such corrupt practice. Kindly mark it. The date and place of the commission of each of such corrupt practice. Then verification is provided by class C. There is a proviso which is very important for us. Clause C shall be signed by the petitioner and verified in the manner laid down in the Code of Civil Procedure for the verification of pleadings, provided that where the petitioner alleges any corrupt practice, the petition shall also be accompanied by an affidavit in the prescribed form in support of the allegation of such corrupt practice and the particulars thereof. Kindly mark this. This is held to be mandatory. And failure to comply with it would be fatal to the maintainability of the election petition. So, there is an allegation. I am taking this test case. There is an allegation of a corrupt practice under section 123, clause 6. Subsection 6, subsection 123. That's a very serious allegation. So it requires an affidavit. Apart from giving the names, the places, the time, and the dates of commission of it, they have to give an affidavit to support the allegation of corrupt practice. Now that affidavit is prescribed under Rule 94, capital A. Kindly permit me to read Rule, say, very short provision. 94, capital A.
I think in that Gauri Shankar's matter referred to all these aspects also.
What then? I don't know.
It is.
Yes, I've gone through it.
No, wrong. 94A ಬರಲ್ಲ.
Form of affidavit to be filed,
ಅದು ಫಾರಂ 94 ಹೌದು
94 capital A.
ಫಾರಂ 25 ಅದು
ನೀವು ಫೈಲ್ ಮಾಡಿದಿರಿ.
ಫಾರಂ 25
ಹೌದು, ಅದನ್ನು I will refer to that as well. Form of affidavit to be filed with the election petition. The affidavit referred to in the proviso to subsection 1 of section 83 shall be sworn before a magistrate of the first class or a notary or a commissioner of oaths and shall be in form 25. Now kindly see the form for a minute. Form 25 making. So every allegation of a corrupt practice should be supported by an affidavit. Now, that is why a format itself is prescribed. I so and so, the petitioner in the accompanying election petition calling in question the election of Sri so and so, make solemn affirmation on oath. Kindly mark it. Kindly, what are the requirements of this affidavit? That the statements made in paragraphs dash of the accompanying election petition of about the commission of the corrupt practice of. So paragraphs in the election petition should be mentioned. In the corrupt practice of, the name of the corrupt practice should be mentioned. And the particulars of such corrupt practice mentioned in paragraphs dash. Particulars where that corrupt practice is described in the election petition should be mentioned. And of the same petition, and in paragraph so and so, the schedule annexed thereto are true to my knowledge. So if it is true to my knowledge, A, paragraph A is the prescribed format. If it is not so, clause B, that the statements made in paragraph so and so, the said petition, about the commission of the corrupt practice of dash, and the particulars of such corrupt practice given in paragraphs dash of the said petition, and in paragraphs dash of the schedule annexed thereto are true to my information. So that either it is true to information or true to the personal knowledge of the deponent. So this is what, and this is required to be given in respect of each corrupt practice that is alleged in the petition. Now kindly come to, just to test the maintainability of this election petition. Kindly permit me to show from the election petition that the election petition runs into 62 pages. That prayer number B at page 55 may kindly be perused. Declaring that the respondent has committed corrupt practice under section 123(1), that is corrupt practice number 1, 123(2), corrupt practice number 2, 123(4), corrupt practice number 3, 123 clause 6 of the Representation of People Act. So this is corrupt practice number 4. 123(6), specific prayer is made And he was not qualified to be chosen. That I will come to it later. So 123(6) is the allegation of corrupt practice against the respondent. At this stage itself, I would request the court to kindly take judicial note of the fact. There is not a whisper in the entire election petition as to how much I have spent. Or as to how much I was required to spend. I would not have spent the entire amount on one day. Maybe I would have spent it immediately after filing the nomination. Maybe after 2 weeks. If it is the case of the petitioner that I have been spending so much money, there is no contemporaneous data or material alleging that I am crossing the limits prescribed under Section 77. He has come to 35 lakhs. He is about to cross 35. He is about to cross 38. He has crossed 40. No. Not a whisper in the entire election petition. He never complained to the returning officer. He never complained to the election commission. If I may say so with respect, all these charges have been cooked up only after I became the chief minister of the state. Not till then. And after I became chief minister, in a great hurry, these charges are cooked up and they are put in the form of this affidavit. So I'll first, now this is the prayer made. Disqualify me because I have spent more money. Now straight away come to the affidavit that is required to be filed, Form 25. That will be found at page 61. Para 7 is the only relevant paragraph. Regarding the averments made by me pertaining to materials, facts, and material particulars for corrupt practice under Section 123(6), incurring or authorizing. Incurring or authorizing. Either I have incurred it, that is the allegation, or I have authorized the incurring. Here it says incurring or authorizing the expenditure. How much expenditure? 70 lakhs, 80 lakhs. What is the allegation? Not a whisper. Expenditure in contravention of Section 77. (77) by itself never prescribes a quantum. It is Rule 90 which prescribes. If I violated, I should have violated 90. And the rules. Section 77 of the representation of patent. Sir.
The body of the petition doesn't refer.
Sir, I'll straight away, only one more line in this affidavit. Crucial. I've come to the crucial. I state that they are in paragraphs 74 and 75. Sir, kindly stop for a minute. Come back to the election petition. So the last paragraph in the election petition, it ends at page 54. Last para is 27. Now, this is a verification of paragraph 74. Sir, I don't know from where to get it. I'm supposed to meet this allegation. ಹಳಿ ಮೇಲ್ ರೈಲ್ ಬಿಟ್ರೆ ಅದು ಎಲ್ಲಾದ್ರೂ ಒಂದು ಡೆಸ್ಟಿನೇಷನ್ಗೆ ಹೋಗುತ್ತೆ. ರೈಲ್ ಬಿಡೋದಕ್ಕೂ ಒಂದು ಹಳಿ ಬೇಕು.
Some mistake has happened. Verification.
Sorry, I will not, no, I object. I'm making out a case. Yes, never, no, I am sorry. I'm making out a case. As the record stands, it is paragraph 74 and 75.
No paragraph 74 and 75.
It is not an error. It is a deliberate, calculated mischief.
Then there's no paragraph.
It's a mischief. I'm going to demonstrate. Every one of these words has come into existence only after I became chief minister. Vindictive, reckless allegations. So 74 and 75 are not there, sir.
Yes, 24 and 25, 25 and 36, instead of that paragraph, number is wrong. Number is wrong, I'm making an application. Because Supreme Court itself was allowed. In Ravana's case.
So after paragraph 27, there are no further paragraphs in the petition.
I agree with you.
So non-existent paragraphs are verified in the affidavit.
I admit there is no paragraph.
There is no allegation of any corrupt practice in para 74 because para 74 itself is not in existence.
It's a mistake, paragraph 25. I will, because.
Then kindly permit me to read the next sentence, sir, in the affidavit. Sir, I read out the format. It says, these paragraphs are true to my knowledge. If it is format A. If it is format B, they are true and I believe them to be true. It is based on information. Now kindly see what is the verification then. I state that they are true. I further state that the same are within my knowledge and information and I believe them to be true. It can't be both. That is no verification. I'll place the authorities. It is true to the knowledge as per 25A or true to the information as per 25B. So this is the affidavit, sir. It said all important serious allegation of corrupt practice. Now kindly come to the pleading. Prayer I have already read out. Kindly come to page 56. Because it is also required to be verified the manner in which a plaint is verified. Kindly come to 56. I, S.M. K.M. Shankara, petitioner herein do hereby verify that the statements made in paragraph so and so, so and so, so and so, so and so are true to my knowledge.
They're reading from page
56. Bottom of page 56, enter the election petition. There is a verification column.
Verification could always could be rectified. That is what Supreme Court has laid down. That's a mistake.
So they are true to my knowledge.
You can, I will.
The statements made in paragraph so and so are based or are true to the information.
Yes.
The statements made in paragraphs 15, 16 are based on the belief. The source of information is the statement made in the manifesto, in the newspaper, in the pamphlets, in the electronic media, in the social media. In paragraphs 1 to 76, sir, once again, it is off the track. Petition is running away to para 2076. Sir, the whole object of the pleading is to give me an opportunity to meet the case that is made out. Sir, where should I go in search of these paragraphs after 27 up to 76, which are verified as true, as based on personal knowledge and on legal advice? Hmm?
This is the
Sir,
result,
this election petition is followed by another affidavit.
this is the result of copying testing, Madam.
Madam, you want to argue, I will sit down. No, you want to argue, I will sit down. Please don't interrupt me. Either you argue or allow me to argue. No, I am making out a case. Please bear with me. Or you want to argue my case also, I'll sit down.
I wanted to bring to your notice that.
Sorry, I am on my legs.
Yes, please.
I am on my legs.
Please.
Sir, this is a verifying affidavit, sir. Kindly come to page 58, sir. Para 2, may kindly be seen. I submit that the statements made in paragraph so and so are true to my knowledge. The statements made in paragraph 14 so and so are based on or true to the information. The statements made in paragraphs 15, 16 are based on the belief. The source of information of the statements made in manifesto, newspaper, pamphlets, electronic media, social media, in paragraphs 1 to 76 are based on legal advice and are true to my belief. Sir, which electronic media, which pamphlet, which newspaper, which manifesto, which social media? Is it the email? Is it the WhatsApp? Is it the Instagram? What is it? Every mandate of section 83(1) and the proviso 83(1)(c) has been thrown to the wind. Sir, can we call this an election petition? I asked this question myself. Is it an election petition? No verification, no affidavit. Is it an election petition? Bundle of lies. They were required to give a bundle of facts constituting the material facts. Bundle of lies. Sir, it is not as if this allegation is not borne out by the pleadings. Kindly permit me to trouble the court in that behalf. There is an allegation of 123, corrupt practice, spending more money under subsection 6. Sir, kindly come to page 52. There are two important paragraphs where I have been alleged to have committed the corrupt practice of incurring expenditure beyond 40 lakh rupees. Two paragraphs are there, para 23 and 24. Sir, 23 quotes the provision. At least there they should have been true to their information. Kindly, corrupt or authorizing an expenditure. Where is corrupt, sir, in section 70? 123.6. Where is corrupt 123.6? One 26 reads, incurring or authorizing an expenditure in contravention of section 77. Whereas petitioner is not only misleading the court, he is misleading the whole world by saying section 123.6 says corrupt or authorizing an expenditure in contravention of section 77. So this is false. This is false to the knowledge, false to the statute, false to the legal advice. So that is one first paragraph. Kindly come to the second paragraph. Have I spent 40 lakhs? Have I spent 50 lakhs? That is very important. Let me read out the allegation. In the instant case, the respondent filed the returns, bringing it within the authorized expenditure. Sir, am I supposed to file a return overshooting the prescribed expenditure? Is it a corrupt practice to put it within the prescribed expenditure? So that is the first allegation. Second allegation, while doing so, he has not included the expenditure incurred for providing the manifesto. Guarantee cards, advertisement charges in various newspapers, expenses incurred for having votes, canvassing votes, expenditure that is being incurred by the government for implementing the schemes. Sir, manifesto, am I supposed to, it is a party manifesto. Am I supposed to bear the expenditure and declare it in my return of expenditure? Government expenditure for implementing the scheme. Am I supposed to bear that expenditure? Is it prior to my election or after I became chief minister? When did it happen? Would it be a corrupt practice? Let us assume as chief minister I have incurred. For implementing these schemes, each guarantee exceeds more than the minimum amount of 20 crores. Don't know why this minimum amount, from where the petitioner gets this 20 crores. It is either 40 lakhs or not 40 lakhs. Anyway, 20 crores exceeding the expenditure by the government at the cost, exceeding the expenditure. I never knew that there is a limit on the government expenditure. Exceeding the expenditure by the government at the cost of the taxpayers. Sir, is this an allegation of a corrupt practice, sir? If the respondent is taking advantage of the guarantee, if they are implementing at the cost of the government, it not only amounts to an offense punishable under the Representation of People Act, also amounts to embezzlement of the government money on either account if the expenditure is beyond the limit and they have to be disqualified. Sir, either I am guilty of a corrupt practice or I have already suffered a disqualification when I filed my nomination.
Yes.
Sir, this is all the allegation on this corrupt practice. Such an important, this thing. There is not a whisper about how much I spent, when did I spend, how did I spend, where did I spend, did I spend it on my vehicles, did I spend it on my car, did I spend it on the pamphlets, did I spend it on my posters? Not a whisper, sir. And when did I spend? Hundreds of villages in my constituency. In which village have I spent it? Mysore city is part of my constituency. Did I spend in city or in the villages? Not a whisper. This is all the allegation, 123(6). 2 paragraphs. One misquoting the provision, another a speech. Probably this was an election speech somewhere. That has been downloaded into para 24. So this is, I'm just giving a test case of one serious allegation of corrupt practice under 123(6). Sir, this honorable court had occasion to, I said I'll stop at 4. Shall I continue? Gauri Shankar has considered this aspect. I'll come back to it. Else, stop. 4 o'clock. She's waiting for your written submission. She'll make an application. Correct. When 25th at 2:30. Please. Matter for further hearing. On 25th at 2:30. Please.
Short password. Ravindra Council has engaged my senior most.
Which man?
Serial number 11 notes.
Have it tomorrow.
I'm told there is option for tomorrow, minutes. There is some urgency.
How many times to pass?
Yes, minutes.
You take a chance tomorrow. Next. And the password is Bandre Berlin password.
$77 also. Senior is developed in 14 minutes.
I'll hear you. Just wait. Next matter. Subramania, which matter?
72, my lords, which came to be posted from yesterday. Your lordship may.
This is a copy of Annexure C, what petition has been. Can I submit this copy?
Could you?
This is a copy what I have obtained. The certified copy, I'll submit it later.
May kindly recollect, my lords, this is a matter where lords, the proceedings were initiated by the authorities, lords, under the provisions of the BBMP Act for the lords alleged violation of lords the building bylaws. Lords, in which lords appeal is filed. When the appeal lords was pending consideration before the Chief Commissioner, an amendment application lords came to be filed by the petitioner hearing. That application lords was outrightly rejected lords at the on filing itself. And thereafter, lords, the Chief Commissioner lords stated that the matter is now posted for orders and we will not be allowing you to make any submissions.
What is the application?
Lords, the application lords for amendment is with regard to lords the jurisdictional issue. Lords, the orders lords were passed by the authorities, which was not competent to lords pass such orders. Lords, that is under section 240A. The assistant executive engineer lords issues the provisional order and the confirmation order. Where lords, the act says that it shall be the zonal commissioner. With regard to that, lords, jurisdictional issue, lords, application came to be filed, seeking amendment of lords the appeal memorandum. Lords, that came to be lords rejected at page number 31. Lords, the typed copy of the order sheet that is dated lords 3/2/2024. Where lords, the Chief Commissioner says, case called, the appellant is present, the respondent number 3 and 4 present, appellant advocate absent. The appellant is asking to move an amendment which is being disallowed at this stage. The appellant is asked to argue if he wants. He does not argue but seeks time, which is not allowed. The appellant is allowed to file written arguments in the office by 9/2/2024, and a copy of the same can be given to the respondent number 3 and 4. If they come to the office to collect, the respondent can give their rebuttal by 17/2/2024. Call on 17/2/2024. Note the status. No physical hearing will be allowed on that day. Call on 17.
My lord.
After lords.
Just wait.
Lords, after the dismissal of lords, my application for amendment, lords, the present writ petition is filed. Lords, when the matter came up before lords, this honorable court, your lordships, lords, orally directed the counsel for the BBMP, asking lords him to communicate it to the Chief Commissioner, not to precipitate the matter. Lords, when the matter came up, lords, on the other occasion before the Chief Commissioner, lords, at the lords, submissions made by the respondent number 3 and 4 hearing, lords, the Chief Commissioner says that there is no order in writing, so far as the interim order is concerned. That is why, my lords, he posted the matter for orders, my lords, is the submission. Though, my lords, it appears the council had communicated it to the Chief Commissioner, my lords, by way of a letter, I believe, my lords, in writing.
Where is the application?
Lords, the application, my lords, is so that is
Should be
lords, annexure page 32. Page 32.
This is the memorandum of appeal.
No.
Page 32.
Lords, page 32, my lords, is the application. Lords, page 37, my lords, is the appeal.
I think some annexure.
B, my lord.
B.
Annexure B.
Annexure B is memorandum of appeal.
In page number 33, the application begins.
That's immediately after the typed copy of the order sheet.
Page 41, annexure C, isn't it?
That's a page,
That is the original appeal memorandum.
that is the appeal, appeal under the 253. That's the application filed. Made that report, sir. 47. Sorry, sir.
Page 41.
Page 41. Okay, there are appeal one. There are appeal one.
One submission, my lordship. If my lordship sees the order sheet of the appeal, where my senior counsel has pointed out the order dated 3/2/2024. Before that, my lordship, it was the stage when the application was filed was of the argument, my lordship. 3/2/2024. I don't have the page number in my reputation. Here it is heard and put for arguments on behalf of the appellants.
Yes.
Finally, so it is at the stage of argument only, the application was filed, my lordship.
No, that's okay. What is there now in allowing it? Even now you can allow it and consider it along with the.
My lord, can I make?
Okay, okay.
I leave it to my lordship. What is?
Can I make a submission? My lord, I gave the, today I submitted the order sheet copy. Apparently the petitioner has submitted only the relevant portion of the order sheets, my lord. In the order sheets, what I have submitted, my lord, can I kindly request you to peruse the page number 92? There is a typewritten copy, my lord, what I have submitted. So from 92 to 96, they are the typewritten copies of whatever the chief commissioner has written. So, my lord, as it can be seen here, the statutory appeal was preferred on the 25/5/2023. That was after I had applied the writ petition number 10418. Several hearings had been concluded before the 3rd of February, what the petitioner is seeking now. So according to the Supreme Court judgments, there is no due diligence nor any kind of, the trial had already begun in this case. The Order 6, Rule 17, the necessary ingredients are due diligence and trial to be pre-trial.
Now, an aspect of law, ground on law, can be raised at any stage even without a pleading. He is only, just wait.
Yes, ma'am.
Now he has made some submission stating there is no jurisdiction. Now let that be amended. He'll consider, when passing final orders, let him consider.
My lord, I would like to make one more submission on that jurisdiction issue. Before going to that, in Order Rule 6/17 itself, in the affidavit filed by the petitioner in the amendment, he seeks in that submission that I submit that at the time of filing the appeal by oversight. So a recent judgment in Basuraj versus Indra, the Supreme Court has held on 29th February. A oversight is a direct indication that the appellant or the person seeking amendment has not shown due diligence. And rightfully, it was at the end of the trial. So that is the reason why the amendment was rejected by the Chief Commissioner, my lord.
No,
My lord, as far as the jurisdiction is concerned, this honorable court itself.
I'm aware of that. Matter is still pending the.
Yes, so when there is this agitation of this matter is not at all required, my lord.
That we can't say because we don't know what will happen in the writ appeal.
True, my lord, but there are thousands of apartments which have been going on illegally. If suppose, let's say, there is a blanket statement telling that ADTP, as the petitioner said, it is wrong. AEE is not the one who has given the order. ADTP, who is the sanctioning authority of the plan, who gave the plan sanctioning right back in 2020, is the authority. According to the circular by the chief commissioner, he has to do periodical checks and find out whether the impugned properties are going on according to the plan sanction or not. Well, anyway, they have derelicted their duty. Finally, there was a two writ appeal. This is a third form of litigation. There is a third round of bout of litigations here. So first, in 2020, we were the.
No, now we are not passing any order on merits. What we are saying is,
my lord, this petition, what they have sought, they are trying to agitate whether 248 can be given by the ADTP or not. So that is already decided by the divisional bench in 1176 of 2023, telling that they needs further adjudication till such time there is a stay. In the writ petition number 2193, your lordship has submitted, ordered that once such is a stay there, no agitation of this jurisdiction.
let the chief commissioner take note of it and pass appropriate order.
That's all, my lord. This amendment, what has been rejected, is rightful, my lord, because they have sought it at the very end of the trial.
Not a trial, it's only a quasi-judicial.
My lord, see, it's almost like a trial. If
no, it's not. It's not at all a trial. It's a quasi-judicial.
My lord, if this amendment is allowed, this adjudication will go back to 2 years, my lord. This is because if suppose, let's say,
it's a legal question. I'll fix a date. On the date they're going to file, they'll have to make their submission and file written arguments on this point.
Written arguments, everything is over, my lord. It is already posted for. See, even if this amendment is allowed, there is the impugned property is under the Mahajar was conducted by this honorable court itself in 22/9/2022. It has already been deemed to be illegal.
We are not on merits of the matter. Now they've raised a legal contention. Let the application be considered and let him file written arguments on the same day and let him proceed further.
My lord, again, another issue what the petitioner has raised is that whether impleading me itself is correct or not in the appeal.
Here it's only impleading.
There is another question in the petition. The petitioners are telling whether why I should be impleaded even in the appeal, statutory appeal. See, I was the de facto complainant in the writ petition.
That is not before. I'm only on the question of.
In one of the contentions, they have raised that also, my lord.
I'm not going to touch on that.
Yes, ma'am.
That is, my lords, on his application before the authority.
No, anyhow,
those arguments are being advanced there, my lords. That is not before, my lords, in the present writ petition.
the petitioner has filed the present petition seeking to call in question.
My lord, I would like to intervene only one more point, my lord. There was in the writ petition number 10418, there was an order to the chief commissioner telling that a sealing time was given of 2 months, my lord. That ended on 20th September 2023 itself. The chief commissioner has not passed any order, my lord. Even after the deadline, there is an agitation of this appeal. Kindly make an order telling that there should be a ceiling limit for this completion of this adjudication. Man. It's already taken close to an year in the statutory appeal itself.
Against that order. Against that order.
Catch hold of Pawan Kumar and shake him up.
In the 253 subclass 2, my lord.
Against that order.
My lord, 253 subclass 2 clearly states the chief commissioner is bound to pass an order within 60 days. And now he has not done that. Nor he has obeyed the court order in WP 10418, my lord.
Let us see. The petitioner has sought for setting aside of the order dated 3/2/2024 at annexure A, whereby the chief commissioner has disallowed the amendment application with further direction that written arguments were to be filed.
The petitioner did not submit any written submit.
By a date to be fixed. Full stop. The petitioner, who is the owner of the property and is the appellant in appeal number 66 of 2023, filed challenging the orders under 248.
Yes.
Yes, ma'am.
Under 248. has filed the present petition. Next. During the pendency of appeal filed under 253 against the orders under 248, the petitioner stated to have sought filing of application under Order 6, Rule 17, seeking to raise contention that the authority which has passed an order under 248(2), that is the provisional order, as well as the
No, my lord, the confirmation is order also passed, my lord.
just and as well as the confirmation order under 248(3) have been passed by an authority / officer who has no jurisdiction. Full stop. Amendment had sought to introduce para 13A and 13G. Full stop. The order sheet would reveal that the said application has been disallowed. Full stop. The respondent number
4 and 5. I am 4.
Respondent number 4 has raised various contentions, including that the application was filed at a belated stage, that the question regarding jurisdiction is a matter. The question regarding jurisdiction is apparently on the basis of the order passed in WP so and so, which has been stayed by the
1176.
has been stayed by the
Appeal number
has been
1176.
stayed by the division bench. And if that were to be so, the appellate authority cannot consider the aspect of jurisdiction, and that application has been filed only to protract the proceedings. Next, as a rejoinder to such submissions, Land Council appearing for the petitioner submits that the aspect of jurisdiction is still not finally settled as the matter is pending in the writ appeal, and in the event of subsequent proceedings, the petitioner may be prejudiced for not raising the contention regarding jurisdiction before the appellate authority, and accordingly submits that the contention regarding lack of jurisdiction is an aspect which is not only a question of law, but is an essential argument of the petitioner that needs to be placed on record. Land Council appearing for the respondent BBMP Shri Pawan Kumar submits that the petitioner has been prolonging the proceedings and accordingly supports the order of the Chief Commissioner. Next. Heard both sides, it must be noted at the outset that the question of jurisdiction is a question of law. Noticing that the final orders are not yet passed, there would be no prejudice as such if the application is allowed, though putting the petitioner on terms. Next, insofar as the contention regarding stay by the order of the division bench of the order of the learned single judge, which had held that there is no jurisdiction, that is a matter touching the merits of the case, and hence no comments are made regarding such aspect. However, it is in fact the submission that writ appeal has not yet been decided is a matter that is taken note of, and accordingly such contention raised can be a part of record without entering into the merits of how such contention is to be addressed. Next, insofar as the contention accordingly, taking note that the matter, the orders are not yet pronounced, and also that the Chief Commissioner has summarily rejected the application without assigning any reasons except a reason that is to be inferred that the application was filed belatedly. The order disallowing the application of the petitioner dated 3/2.
2024.
2024 is set aside. The chief commissioner is directed to consider the application and proceed with the matter. Insofar as arguments to be advanced on application seeking for amendment, the petitioner is not to seek any adjournments, but argue the matter on the day on which the application is taken, and is also directed to file written submissions in support of such application.
My lord, can we request a sealing time for the final order, my lord? Because the elections are coming and the BBMP will close down.
There's only one chief commissioner, is it?
Yes, my lord.
How many, you'll have to make arrangements.
There will be special hearings in his office itself, my lord.
Same argument, my lords, was advanced in a writ appeal, my lords, where the writ petition order was challenged, my lords, by the respondent number 4 and 5.
Let me finish just. Accordingly, petition is disposed of subject to the above observations. Now regarding infrastructure, etc., you will have to have many more chief commissioners, however, because there are large number of cases. 1. 2, pressure of work can be no reason for writing 50 orders. Everybody will come here because they have their grievance. You must have better infrastructure, more people to deal with it, more assistance, and do it professionally.
At least, my lords, when the orders are communicated, my lord, your lordships, my lords, made such observation, my lords, notwithstanding my request that let it be in writing. My lords, your lordships orally communicated him, my lords, to inform the commissioner not to proceed or not to precipitate. But despite that, my lords, proceeding ahead, my lord, that may not be, my lords, proper on the part of the chief commissioner.
As such, the chief commissioner has also.
In fact, my
made a
lord, my
contempt
learned
not
friend
crossing
has
an order.
communicated in writing.
What has happened, my lordship, my lordship has said till 20th. Till 20th, no orders were passed. Then the bench changes and it was come up before coordinate bench, which is not before me, they have said. Then the direction was not continued. So that some
Lord,
cloud
the
was
chief
there.
commissioner is habitual, my lord, even though there was a written order in WP 10418 to complete it within 2 months, way back in July, he did not bother to have any hearing nor complete the adjudication. When we asked orally, he says, you can go and file a contempt.
No,
That is what the chief if the chief commissioner
Too much of-
himself is so adamant,
No, correct.
the ADTP and AEs, they are very much lower officers.
No, they have to make arrangements.
They
because-
take law into their own hands, and illegal properties are pruning up every second of the day, man. We are aggrieved neighbors of this impugned property, and that's the reason why we are here in front of this court.
Let us see.
Your lordship, your lordship, one submission, your lordship, serial number 11 passed over, your lord. Tomorrow is the last date of co-option, your lordship. That's the reason. Sorry, your lordship, for causing.
Yes.
Your lordship, the petitioner, your lordship, this is also a similar as earlier, your lordship, co-option, your lordship, respondent number 2, union, your lordship, has issued a letter, your lordship, void annexure C, calling its own manager, your lordship, stating that you provide me the eligible list by 1st of March, 6th of March 2024, your lordship. All the primary societies eligible list to co-opt in the place of one M. Rupa, your lordship, who has been terminated after having disqualified, your lordship. Thereafter, your lordship, on the very next day, your lordship, your lordship, the managing director, instead of waiting for the list, he himself has prepared the list, your lordship, in this thing, wherein my item number is, my society is in item number 21, page number 20, your lordship.
No, which is the letter annexure C.
C is a office note. Office note, your lordship.
Now this proceeding is drawn up by whom?
By the managing director. This is in concern to only Madur Taluk, your lordship. And in item number 21, your lordship, that is in page 20, your lordship, annexure, the list, the managing director, he himself prepared, your lordship, without giving a manager who is a manager procurement to procure all the primary list members from the primary societies. In item number 21, in page number 20, your lordship, my societies, no person's name has been mentioned, though I am eligible candidate to co-opt in the co-option proceedings, your lordship. In item number 21, your lordship. Everything is left blank. Like that, your lordship, all over 41 primary societies has been left with an intention only to co-opt those persons. They are hand in glove with each other to favor some persons, your lordship.
When did the vacancy arise?
Vacancy, your lordship, 29, vacancy. 21st February, your lordship,
21st February?
2024.
No, I'm saying this co-option, vacancy arose when?
21st February 2024, your lordship.
By resignation?
Not resignation, disqualified. The director, earlier director has been disqualified and the vacancy has been created in that place, your lordship. To fill up that vacancy, your lordship,
No, correct, but now they have to follow the procedure.
they have to follow. They have not followed the procedure, your lordship.
But now how we can compel them at this point of time?
Please, your lordship.
How can we compel them at this point of time? It's not only a month since the vacancy arose.
Please,
Now,
your lordship.
They may have
Within
challenged
a one,
No, they may have challenged the disqualification, we don't know.
yeah, they have been challenged. That is it.
Where is the vacancy now to co-opt? Unless the vacancy becomes a clear vacancy, how can you say you have to be co-opted?
Your lordship, 7.3 annexure C1 is the paper, document, your lordship, annexure C1, that is the
29?
notice.
No, 29E.
29E is the vacancy.
Correct.
1 month they have to wait, your lordship. Here they have not even waited for a 1 month. Within 15 days, your lordship, to favor some, leaving upon all other primary society itself.
The vacancy arose on 21/2.
Please, your lordship.
So now your argument is that?
Your lordship, my argument is that they have invited some of the primary members, your lordship. Only some of the primary, there are around 190 primary societies in the Maddur Taluka, out of which only few members they have
co-opted.
Not co-opted, they have invited the eligible list, your lordship, give whoever the interested person. Giving up around 40 primary other societies, your lordship.
They have not asked.
They have not asked. And the managing director, what he has done, instead of waiting for the procurement, what he himself, managing director, has sought from his manager, another section, your lordship, to provide the document. He started himself to prepare the eligible list, your lordship, that is in annexure D.
No, who are you now? You are the?
One of the primary society member, your lord, eligible society member.
From your primary society, what they have not?
They have not invited nothing. My name has shown, my director names has been excluded, your lordship, from the list itself. Not only my primary society, the other societies around 40 members. 40, they even do not know.
Our primary society now is administrator is appointed, is it?
No administrator has been appointed.
So why there's no delegate from
His primary society should tell that why he is not delegated. If he is having a confidence over his primary society, then they will delegate. If he is not delegated, what right he is having to question?
Which is that form?
Not delegate form, my lord.
No, my lord.
Why you have not submitted a delegate?
No, here what?
Here the delegation
May I
do
request,
not
my lord?
question at all.
May I request?
Delegation do not arise at all, your lordship.
No, why you have not nominated somebody to represent you in the Apex Society election?
Your lordship, they have to give the notice to all the primary society, calling upon to the director's name. Here the question of delegation do not arise. The name of the persons who has in the majority, your lordship, the majority comes in that basis, the person will be co-opted. On the basis of the majority, the delegation do not arise at all in this
These
place.
proceedings were taken under section 29C, my lord. Section 29 capital E, sorry. Section 29 capital E, where the director post of the secondary society will arise and due to, this was vacant due to one of the person was disqualified and he filed a writ petition. He failed to succeed in writ petition, then it has become vacant. By the defect that the post was vacant, the milk union they have a power under the rule. They have called for a meeting for appointing a nominated director. If he have something, he can object there, not to come directly to this court.
They've nominated somebody.
No, they are not nominated. They are called for meeting to nominate.
When is that?
That was, Lord. No, it is only he issued a notice, my lord. May I read the annexure C at Vishaya, my lord?
Yes.
Vakkutada Adalita at page 16, my lord. Vishaya. ಒಕ್ಕೂಟದ ಆಡಳಿತ ಮಂಡಳಿ ಮದ್ದೂರು ತಾಲೂಕು ಮತಕ್ಷೇತ್ರ ತೆರವಾಗುವ ನಿರ್ದೇಶಕ ಸ್ಥಾನದ ಕೋಆಪ್ಷನ್ ಮೂಲಕ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳುವ ಬಗ್ಗೆ. This is he called notice and I think they will fix for the meeting for that day. That is not at all fixed for that day meeting.
No, on 14.3, he says they've co-opted somebody.
No,
They
not
are going to
co-opted, Milord.
co-opt on 14.3, that is annexure
They're
C
not
1.
co-opted at all. The proceedings has to be took place, then they will co-opt.
So what is your submission now? On 14.3, they're going to co-opt.
Co-opt.
Yes.
If
So
my learned friend is saying it's only a
saying
proceedings,
what-
your lordship, let
No.
there be a,
I'm saying, what is your grievance now? On 14.3, they're going to co-opt. So what is your grievance?
your lordship, all the members should be get a equal opportunity at the time of co-option, your lordship, who are the eligible person. List has to be prepared. Thereafter, they have to issue the notice to all the members 199.
Where is the procedure provided for this co-option? Under
29E, your lordship, this is the one, your lordship, in page number C, they themselves have written, your lordship, at last para, your lordship,
page?
page 16, your lordship.
Read.
Your lordship. ಒಕ್ಕೂಟದ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಮದ್ದೂರು ತಾಲೂಕು ಮತಕ್ಷೇತ್ರದಿಂದ ತೆರವಾಗಿರುವ ಸ್ಥಾನವನ್ನು ಭರ್ತಿ ಮಾಡಲು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ ಪ್ರಕರಣ 29 ಈ ರೀತಿ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಪದದಲ್ಲಿ ಮರಣ, ರಾಜೀನಾಮೆ, ವಜಾ ಮಾಡುವಿಕೆ ಅಥವಾ ಇತರ ಕಾರಣಗಳಿಂದ ಉಂಟಾಗುವ ಯಾವುದೇ ಖಾಲಿ ಸ್ಥಾನವನ್ನು ಅಂತ ಸಂಘದ ವಿಧಿಗಳಲ್ಲಿ ನಿರ್ದಿಷ್ಟಪಡಿಸಬಹುದಾದಂತಹ ರೀತಿಯ ಭರ್ತಿ ಮಾಡತಕ್ಕದ್ದು. ಮಂಡಳಿಯ ಉಳಿದಿರುವ ಪದಾವಧಿಯ ಅದರ ಮೂಲ ಪದಾವಧಿಯ ಅರ್ಧಕ್ಕಿಂತ ಕಡಿಮೆ ಇರುವಲ್ಲಿ ಯಾವ ವರ್ಗ ಸದಸ್ಯರಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸ್ಥಾನ ಖಾಲಿಯಾಗಿದೆಯೋ ಅದೇ ವರ್ಗದ ಸದಸ್ಯರ ಪೈಕಿ ಸಹಮತದಿಂದ ನಾಮನಿರ್ದೇಶನ ಮಾಡುವ ಮೂಲಕ ಮಂಡಳಿಯಲ್ಲಿನ ಖಾಲಿ ಸ್ಥಾನವನ್ನು ಮಂಡಳಿಯು ಭರ್ತಿ ಮಾಡಬಹುದು. ಅಲ್ಲದೆ ಪರಂತು ಆಕಸ್ಮಿಕ ರಿಕ್ತೆಯಂತೆ ಸ್ಥಾನಗಳ ರಿಕ್ತೆಯಂತೆ ದಿನಾಂಕದಿಂದ 3 ತಿಂಗಳೊಳಗೆ ಆಡಳಿತ ಮಂಡಳಿ ತುಂಬಲು ವಿಫಲವಾದಲ್ಲಿ ಅಂತ ರಿಕ್ತ ಸ್ಥಾನ ನಿಬಂಧಕರು ನಾಮನಿರ್ದೇಶಕರ ಮೂಲಕ ತುಂಬತಕ್ಕದ್ದು ಎಂಬುತ್ತಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ
Just 1 minute. Now 3 months have not yet lapsed.
not yet lapsed.
So you are saying that it cannot be filled by nomination.
No, it has to be filled.
How can it be filled till unless 3 months have lapsed?
There is an option to the board to nominate, my lord.
After 3 months.
Allah, within 3 months.
Within 3 months.
3 months, they are option open to the.
Then
board
after
to
that, the
nominate.
state government will have a power, Milord.
Within, if you
Lord,
fail,
may I request, Milord?
my lord, they fail to fill within 3 months, then a registrar is powered
The-
to fill.
The
my lord.
post has to be filled up by the second respondent, that is a Mandya District Cooperative Milk Producer Society Union Limited, Milord. That has to be filled by that. But any aggrieved person, that is only his society, not by him, my lord. That is my contention.
No, correct. Now, within 3 months, the board can fill.
The board can fill up.
Can fill, isn't it?
Obliged, Milord.
Now it is at that stage still.
Yes,
Has
my
not
lord.
yet lapsed.
The post is become vacant on 2024.
21 to 24.
2024,
So-
because the writ petition were dismissed.
So now within the 3 months, they can fill it.
They can fill it.
Yes,
After 3 months, the government will have a power under second provision,
Yes.
next provision.
So now meeting is fixed for considering.
ಇನ್ನು ಮೀಟಿಂಗ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ, ಡೇಟೆ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ ಎಲ್ಲೂ.
No, this.
Your Lord, Annexure C1.
Just one.
It's only intimation.
Annexure C1,
ಹೌದು ಸ್ವಾಮಿ.
he says on 14/3 we'll have a meeting,
ಹೌದು.
isn't it? So on that date, they may consider who to co-opt. At annexure C1,
Obliged, Lord.
they may consider who to co-opt.
ಹೌದು.
That is the date fixed for the meeting.
ಹೌದು.
So what is your grievance on that day? They may consider you also.
He also, his
Huh.
society will represent, not he.
Lordship, my names are not in the eligible list, your lordship, like that 40 members, primary society, in page 21, your lordship.
For co-option, have they made a list?
They have to prepare the list by giving a notice to all the primary societies, sir.
Where is that procedure?
Your lordship, in page number 19, annexure D, your lordship.
Annexure?
Annexure 19, this has to be done it through by the board, your lordship, where managing director has
Which
prepared.
section of which rule provides for this preparation of this list?
Your lordship, same class person means all the notice should be provided to the primary society who are same class of person,
No, I'm saying
equal opportunity.
correct. Where is the procedure provided for preparing list for the purpose of co-option? Is there some rule by law? Is there any procedure prescribed?
Your lordship, eligible candidate, actually board has to prepare, your lordship. It is the duty of the board to prepare the eligible list. They can't give one person, one primary society and other, they should not exclude. This is the list prepared by the managing director of the board, your lordship. Annexure D in page number 19, your lordship.
Annexure C, is by the primary society, isn't
No,
it?
secondary society.
Secondary society, that is the
Respond number two,
second
Milord.
respondent milk union, Your Lordship.
The apex society or the primary society?
Apex society. Your Lordship.
Apex. Society.
Milk union. Milord. It is at district level.
Now, the decision to appoint a person to act as a delegate is to be made by the
Second respond milk union.
Board,
by the apex society.
please.
Milord, may I request, Milord? He is a member of the primary society. He did not make a party to the primary society. That is one contention. That is another is that he is saying that I am a member of the primary society.
No,
They
no,
are going to co-opt for the secondary society.
no, correct. But now the co-option power is conferred on the primary society.
Illa, secondary society.
That is the
Respond number 2, that is
apex body.
apex body. Their directorship was becoming vacant. So they are going to fill up. He is a director of the secondary primary society. He doesn't have any power. His society has to come.
I am the society itself a party, Your Lordship.
Society, it is CEO has to
Primary
come.
society is the proper party, Your Lordship. Petitioner.
Now, where is the list you are saying?
Your Lordship, Annexure D in page 19, Your Lordship. Your Lordship, kindly serial number 1, Your Lordship, this is the one society, Alur. And the name of the president, vice president and all other persons has been mentioned on the other columns, Your Lordship. As it is, if it is compared to in page 20, Your Lordship, serial number 21. My society name is there, Congo 21, Your Lordship, Congo Borana Dodi. And nobody's president or director's name has been reflecting. Like that, likewise, Your Lordship, other 40 primary societies' name has been excluded by this, only with an intention to avoid, only to favor those persons. For deliberately, Your Lordship, it has been doing.
No, but
Opportunity should be given and they should
correct.
consider
Your
their post.
society should have challenged this.
That's what I am challenging. Society itself challenged.
Society is
Petition the
representative
society
president.
petitioner.
He
That is
will
the
not be a
petitioner.
part.
You are the president.
ಅವ್ರು ಹೇಳ್ತಾರೆ
My
annexure.
concern only, Your Lordship, let them continue if you want to, let there be this thing after giving a notice, after following the procedure. That's all I'm requesting. Giving a notice and give all the opportunities to all the members primary. It should not exclude some people, pick and choose attitude should not be done by the respondent number 2.
ಅಲ್ಲ 14 ಮೀಟಿಂಗ್ ಫಿಕ್ಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಲ್ಲೂ ಇಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಯಾವುದು ಡೇಟೇ ಇಲ್ಲ.
Annexure
ಯಾವತ್ತು
C
fix
1
ಆಗಿದೆ?
ಹಾಕಿದ್ದೀನಿ ನೋಡಿ. Annexure C1.
Then we can only say in the meeting proposed to be held, Siddharth.
Oblige, Milord.
In the meeting proposed to be held, the second respondent may consider all those from amongst those eligible in the petitioner society while making.
Lord, may I request, my lord, this meeting notice, it goes to only those members who are director of the society. They will conduct a meeting. They will choose the business transaction of the society has to convey under Rule 14A(k)(4). It is not by all the society. They doesn't need to give notice to all the societies where member are affiliated to secondary society. It is only a transaction between the directors of the secondary society. That is the respond number 2. He doesn't have any authority saying that they are conducting. They did not issue notice to me. That is not an.
Lordship, without there being giving
they issued
equal
notice to their director. ಅವ್ರ ಡೈರೆಕ್ಟರ್ ಮೀಟಿಂಗ್ ಮಾಡ್ಕೋತಾರೆ. ಇವ್ರು ಅಪೇರ್ ಆಗೋದು ಹೋಗಿಲ್ಲ, ಅವ್ರ ಮೀಟಿಂಗ್ ಅಟೆಂಡ್ ಆಗೋದು ಇಲ್ಲ. Director will conduct a meeting. They will transact the business. If there is any majority under the such a meeting which is held by the second respondent society, they will appoint a nominated director. That is their business.
Petition society is the direct member of the secondary society.
If he is a director, then he can say that they are conducting meeting without issuing notice to me, then they have a case. But not being a director to the secondary society, that is a second respondent, they cannot say that they did not issue notice to me.
A secondary society duty to collect the all eligible list, my lord. This is a duty to collect all eligible list. then placed before the board. As far as the place before the board, my lord, this annexure D is concerned, my name is deliberately left out. Lord, you are asking to add my name in the list. That will board will decide who is the eligible or not.
The meeting to be held, let the second respondent consider the claim of directors from the petitioners.
ಅದೇ ತಾವ್ ಮಾಡ್ಬೋದು ಬಟ್ ಏನಾಗುತ್ತಂದ್ರೆ ವಿ ಡೋಂಟ್ ನೋ ವಾಟ್ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ದೇ ಹ್ಯಾವ್ ಅಂತ ಅವ್ರು ಬಂದು ಹೇಳ್ಬೇಕು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾನ್ಸ್ ಸೊಸೈಟಿ ಬಿಕಾಸ್ ದಿ ಡಿಸಿಷನ್ ವಿಲ್ ಬಿ ಟೇಕನ್ ಬೈ ದಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೊಸೈಟಿ ನಾಟ್ ಬೈ ದಿ ಸ್ಟೇಟ್ ಆರ್ ಸಮಥಿಂಗ್ ಎಲ್ಸ್. The statute has given power to the second response society. They have a right under proviso 1 that if it is within 3 months, then they have a right. So they are exercising their right. The board is exercising their right. What duty they have, I don't know.
Yeah, we'll say that much, then let them only decide.
Okay. If they are legally eligible, they will consider, otherwise they.
Your lordship, otherwise I have a suggestion,
Intention
your
of
lordship.
the petitioner is that meeting has been called on 14th as per annexure C1. And as of now, in terms of the list at annexure D, none of the directors of the petitioner society are shown.
Not only me, your lordship, around 40
So
societies.
forget about the rest.
Please.
Are shown. Full stop. In light of the contention that if meeting is held without considering the claim of eligible directors of the petitioner society, there would be prejudice caused. It is observed that the second respondent, which may conduct a meeting on 14/3/2024, may consider the claim of directors of the petitioner society if they are so eligible. And exclusion of the names at annexure D ought not to come in the way of such consideration. This order is subject to further consideration. AGA accepts notice for the first respondent, emergent notice to the second respondent. Petitioner may take out notice by way of hand summons.
Your lordship,
Second respondent, list the matter on next week.
Your lordship, tomorrow is the co-option, your lordship.
So we have directed, no?
Please, for a moment, your lordship. Tomorrow, my name should be inclusion, your lordship, in this.
That is for them to decide. We can't direct.
Your lordship, they have to decide, after deciding, after giving an opportunity to everybody, your lordship, the name has
we
to
have
be mentioned.
directed them to
But
consider.
by tomorrow, there is a co-option, your lordship. They cannot prepare the
Lord, may I
eligible
request
list.
not- The co-op
So
is an
that's the reason
backdoor
I'm
entry,
asking,
The
tomorrow,
co-option
instead of
is an
tomorrow, your
backdoor
lordship,
entry.
let there be a co-option, maybe shifted to day after tomorrow.
That's all I can say. We'll see.
Tomorrow, your lordship.
Nale.
2:30.
Tomorrow at 2:30.
Tomorrow at 2:30.
I think the interim order, kindly have it tomorrow, my lord.
75.
Argument is already concluded, senior already complete ಮಾಡಿದ್ದಾರೆ.
Which 75?
Please.
Lord, in that objection is ready, I will serve on him.
Ready, eh?
Lord, one more request, Lord, that one petition at serial number 65, Lord.
Serial number?
That maybe date may be given, any date next.
Serial number 5.
So 65, my lord.
65.
ಹೌದು ಸರ್.
63 on that.
ಅದ್ರಲ್ಲಿ ತಾವು ಅಫಿಡೇಟ್ ಹಾಕಂತ ಹೇಳಿ ಇದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಡು ಅಂತ ಹೇಳಿದ್ರಿ. ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಈಸ್ ರೆಡಿ. ಸೊ ಬ್ಯಾಂಕ್ ಈಸ್ ಅಂಡರ್ವೆಂಟ್ ಫಾರ್ ಲಿಕ್ವಿಡೇಷನ್. ಸೊ ಅದರ ಡೆವಲಪ್ಮೆಂಟ್ಸ್ ಹೇಳಕ್ಕಂತಾನೆ.
65.
ಹೌದು ಸರ್.
When do you want?
Any day it may be taken on
Right, date good.
22nd, my lord.
63. 63. You ask them, give dates. 63. Thank you.
ಹೌದೌದು.
ಅದು ನಾಳೆಗೆ ಎಲೆಕ್ಷನ್ ಇದೆ. ಕಾಪಿ
77 ಯಾವಾಗ? 77. ಹಾ.
Photo officer, serial number 65, you have date.
ಸರ್ ಇದು ಅನ್ನೋದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಓನರ್ಸ್ ಇದು ಕವರ್ಡ್ ಇದೆ, ಇದೊಂದು ವಿಷಯ ಇಲ್ಲ ಅದರಾಗಿ ನಾವು ತಲೆ ಕೆಡಿಸ್ ಆಲ್ರೆಡಿ ಕವರ್ಡ್, ಏನು ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳೋದಿಲ್ಲ.
Sir, serial number 77, ಯಾವ ಡೇಟ್ ಸರ್?
ಚಂದ್ರು